What we have seen is the matter was referred by
Yes.
the coordinated bench of this court. And another decision was already there, it's reported in GLT and GLR. Tell us, who will start? Mr. Sikar, you will start first.
My lord, may I submit before going to the next? My lord, in the same issue, your lordship and then my lord, acting Chief Justice A.K. Goswami also passed an order.
Earlier, yes, we remember,
Yes.
but there is no such, we not say only
So
with
if
transfer.
your lordship please to take, we have to objection. My lord, whether only my question,
In
my
that
lord,
issue,
my
we have
apprehension
not
was
decided anything legally. If you have seen
Yes.
with Justice Goswami, who like that
yes,
particular matter.
that was in
We
that
did not
particular case. In that particular case, your lordship has decided.
Just
Yes,
transfer the
that's
matter,
one
but
an
there is no
order.
such legal decision. We
Yes.
just simply allowed for the transfer.
Yes.
That will not happen anything.
If your lordship would take.
I don't think so. It will that way.
Yes, my lord.
I
Just-
remember
it was
about
my
6
duty to,
cases we have transferred while sitting with Justice
so it
Goswami.
was my duty to point out, so I have to.
I think one of the matter has been mentioned in that judgment when it was referred by Justice.
Yes. In that it is.
But here also it is clarified that no such legal thing has been. They,
In fact-
they don't dare it.
In the my lord order where it, by whereby it is referred, there also your lordships that judgment is referred.
Are we preparing for a final answer today, or are you
My lord, length of hearing is required in this case, my lord. So, my lord,
with the permission of my elder brother? There are two aspects which probably will try to have some input from you. The order of reference is mainly based on a judgment of the Honorable Supreme Court, Anita Kushwaha. You've seen the order.
my lord.
That was of 2016, 5 judges bench. And the division bench by which the reference has been made has doubted this decision in Sariful, which is 2019.
My lord.
But Sariful has taken into consideration Anita Kushwaha. It's not that Anita Kushwaha was not brought to the notice of the bench. It was brought to the notice of the bench, it was considered. And we would be requiring your input on the further aspects of the case, particular fact of Anita Kushwaha. If you have read the judgment,
Well.
have you read the judgment of Anita Kushwaha?
My lord, we have seen, my lord,
Have you seen the
but
facts?
we have to, we
Are
have
you
to,
aware of the background of Anita Kushwaha?
my lord, yes, that was a case of Jammu and Kashmir. And
Are
as
you
far as
also aware under what the Honorable Apex Court, what power it has exercised of the constitutional power
my
provision?
lord, we need, my lord, some more preparation in this
Yes,
case.
in fact, Article 142 was also invoked.
Yes, my lord.
And facts and
That's
circumstances in Anita Kushwaha was totally different. Because of the ongoing situation, they wanted transfer of matters from the state of J&K to other states. This is a proceeding of before a tribunal, FT, which
Yes.
is governed by a particular set of act.
Right.
Whether the act provides for a power transfer, whether 226 also can also be utilized for exercise of power for transfer of a matter of a tribunal. Those are matters which you like to have your views.
Yes, my lord.
I'd like to hear on those points. Mr. Payang also take care of.
And if anyone else want to address on this view, on this
My lord,
reference, you're welcome.
my lord, in the
Mr.
judgment,
Payang, you have just pointed out the division bench
Yes.
in which my elder brother was the
Yes.
party. That was the decision, but the validity as such was not the question.
Not decided. Only in that particular case,
Yes,
maybe
it was transferred, but
Yes.
whether we can exercise powers of transfer or should be done or should not be done, that is what we have
That
to
is a
decide here.
different. That
So
issue
those
has.
decisions, maybe we can
Yes.
distinguish on the fact. But we
No,
want
it
your
was
input.
taken care of in the judgment that was referred.
Yes.
Legality of that thing was not considered.
Not considered
Only
in that
just
case.
Order was passed for transferring of them.
Yes.
The moot point which will arise perhaps is in absence of a power of a provision in the statute can a court exercise the powers to transfer a proceeding? Number one, whether even in absence of such explicit powers, 226 jurisdiction can be invoked. These are the two basic moot questions.
I think, my lord, because this is a peculiar act and
And
peculiar
that is
situation.
also the
Yes,
third point, connected point.
yes, my lord.
We cannot lose sight of the objective of the act.
Act, my lord.
What is the act for?
My lord, act and the order does not, my lord, given a specific bar against the transfer.
Mr. Sikdar, these are affirmative powers. Only because there is no bar we exercise, it's not like that. Just like a review power or a power of an appellate court, unless it is conferred by a statute, you cannot be a review, cannot exercise powers of review. And this is something more. It amounts to transfer of a proceeding.
Yes.
So whether 226 can be invoked to or be so wide to even transfer proceedings, that is what,
My
there
lord,
may be some cases.
my lord, we may be given some time, my lord.
No, not only that, you can
My lord.
definitely have it.
Say the referral court, when the matter was referred, considered few facts, like leaving aside the territorial jurisdiction.
Yes, territorial jurisdiction,
Accepting all
jurisdictional
other
facts.
jurisdiction can be transferred.
Yes,
But
madam.
other thing is this, whether that transfer, exercising the power under Constitution of Article 226,
And in this
can we
case,
transfer a matter from one particular bench or one particular tribunal to another tribunal? Not? Whether you can exercise that power under 220. That's the issue here. As
Yes,
a
ma'am.
brother have
This-
pointed out.
in this
So
case,
we
my
have
lord, it
to
is held
address
that
on those issues.
it is held that if there is, if the competence is there, tribunal is competent, then tribunal, any tribunal within the state of Assam can decide. That has been held, and also held that the view taken in the Shariful Islam case and Moinul Haq case, my lord, the view of the division bench that it's not a lease, it is not a, it is a sui generis, that also not accepted by in this, in passing this judgment. And this and in the judgment also it is held that if the section 11 is applicable in the tribunal case as held in the Abdul Quddus case, then also section 24 are also applicable in this case. So all these issues are discussed, but so far, my lord, the Anita Kushwaha case, my lord, we need some more study, my lord. So we want some time, my lord.
Yes, Mr. Sikdar, you will be for all the petitions or?
No, my
someone
lord,
else?
I am in one case, but some of my friends in other case also,
That's what we want.
they also
else will-
inform me that we need some preparation, my lord.
It doesn't matter. Who else will make submission?
My-
Mr. Sikdar, you are in which item?
my lord. Item 1.
Mr. Sikdar, brother wants to make another.
You also have to look into, you have referred 24.
My lord.
You have referred 24 of the CPC.
Yes, my lord.
see 24, the primary precondition is that the tribunal has to be a competent tribunal,
Yes,
number one. And number two, though it's a general powers of transfer and withdrawal, you have to read 24 with section 141. The proceedings are under the code is not applicable to a writ proceeding,
my lord.
is not applicable to an application under 226. Read 141.
If you say.
So I don't think we should we have to go to 24. We have to generally discuss the powers under 226. Whether powers under 226 are wide enough to even include powers of transfer of proceedings. You see the explanations in this section, the expression proceedings includes proceedings so and so and does not include any proceeding under 226. The express bar is there. The different thing that we apply
In
the
this section, the
spirit.
expression proceedings includes proceeding under order 9, but also doesn't include proceeding under.
Mr. Sikdar, sister is also pointing out that the referral court consider the fact that since there is a power of res judicata with regard to such proceeding, so why not take consider of transfer?
Yes,
You raise it and that's also considered. So these are issues, so there is a power of res judicata. So necessarily if it is res judicata under the CPC, why not transfer under section 24 of the CPC? Therefore,
that
You
has
have
been,
ours,
that has been,
obviously considered by the-
yes, my lord. That has been the
On
objection.
this issue, Mr. Sikdar, res judicata, irrespective of the fact there is a provision in the code, it's a doctrine of res judicata, even without applying the statute, we can still apply doctrine, but there is no doctrine of transfer as such. Res judicata is a common law doctrine, justice, equity, good conscience. Once what has been decided, you cannot again take up, reopen it, even without the taking aid of the CPC. It's a universal doctrine. Justice, equity, good conscience. But is there a doctrine of transfer? Is it a matter of right? Not a matter of right. Transfer has to be conferred, the powers of transfer has to be conferred by a statute. Only scope is that whether 226 is wide enough to have such powers. That's the only scope for you to argue or ours to consider.
My lord. My lord,
142,
we-
22,
we may-
26 are
we may be
different.
given some time more, my lord.
You should only use 226,
My lord.
so that it can be exercised.
My lord, ultimately, my lord, everything, my lord, depends, my lord, ends of justice, my lord. My lord, in the Unita Kushwaha, so I have not gone through properly, but Unita Kushwaha said that the axis of justice, that is,
The situations are different there. That's why brother have asked you to go through and the background of the Anita Kushwaha.
my lord, I may be given some time.
Who else are appearing in this matter? Who are appearing?
Also, I am appearing in matter 2, 3, 5, and 6.
2, 3, 5, and 6. Yes. What is the submission?
Also, need some time to go. Question raised, your lordship. 226, power of 226. Another whether CPC section 24 is applicable or
The
not.
first DB judgment is very clear that in exercise of power 226, it cannot be done, right? Then the second judgment, that's referred to judgment, it is also pointing out that it can be done. That's why matter has been referred to.
Lord. Also, we need some time. We will address this issue, your lordship.
Yes, Mr. Ahmed.
Exactly, my lord, whether under Article 226, this could has the power. Since my lord, CPC, there is a provision for transferring the case from one court to another court. So that this is to be applied here also, because this act is silent about the transferring of the case. philosophically see the nature of the case. Whether the host parties will cause, whether the government has prejudice, if that one case is transferred from Shivsagar to Dhubri, whether the petitioners who are the case pending in the Shivsagar court, they are resident of Dhubri, they are traveling every day to Dhubri, whether if the case is transferred to that place, whether government has caused any prejudice. This is to look to see. If CPC also, that when the case is to be transferred, there is should be show the good reasons. If there is a good reasons, then court has the power. He can transfer it. Then we are seeing that every in criminal proceeding as well as civil proceeding, this noble court has the transferring the case from one district to another district. So for balance of convenience, my lord, so where those people generally why the expected proceeding is going on because they are not able to attend the court from Dhubri to Shivsagar in every day. That is why expected proceeding is going on, my lord. So this court is not a powerless, my lord. Under Article 226, it can be applied. In this case also, there is a order, a loss of LEC order 1964. Power of the tribunal, he can, CPC is applied. Section 4, power of the tribunal, my lord. The Foreigners Tribunal Order 1964, Section 4. The tribunal have the power of a civil court while trying a suit under Civil Code of Civil Procedure 906 in the following matter: summoning and informing attendance of any witness, requiring the discovery of production of any witness, issuing commission for the examination of any witness. That power has been given to the tribunal.
These
Well,
powers are
yeah,
in
yes.
almost all statutes, even if you take up the Consumer Protection Act,
Yes,
the power to secure the attendance of a witness,
my lord.
we examine them, these are the powers which are to be exercised by particular tribunal
Yes.
or forum
Yes.
by exercising powers under the CPC.
CPC.
CPC does not say, that provision does not say anything about 24.
But that is
And it
why
is not a power of transfer by the tribunal, it is a power of transfer which you are trying to invoke from this court under 226.
that is why, my lord, this honorable court also, and as well Supreme Court has clear in some cases says that if the act is silent, then general principle is to be followed. This court is not, there is no provision for transferring, correct, but it does not mean that court has no power. It does not mean, my lord. Supreme Court is held in several cases that although the act is silent, but the court has the power. Even in the General Colleges Act, my lord, the appointing authority sometimes has the power to appoint, but the act is silent that he has no power to cancel it. So General Colleges is applicable because yes, if once he make an appointment, then he has the power to cancel, dismiss it. This is the provisions, my
These
lord.
are different
Correct,
connotation
my lord.
altogether. It's a separate, independent, definite power of transfer.
Yes,
It is not something ancillary. That I do something, therefore I can do the other thing also.
only
Can a court exercise powers of review without there being any provision in the statute? Can a court act as an appellate court without being conferred with as an appellate power?
because problem
These are
is
something which has to be conferred by
no.
statute.
problem is there is no appellate forum. This is the problem. Because earlier, my lord, in
No, no,
every cases,
I'm just citing an example.
my lord,
There are certain things like conferring of an appellate power, conferring
Yes.
of review powers.
Yes.
This is a power of transfer has to be conferred by a statute.
my lord.
Whether 226 is wide enough to include that power, on that direction we have to argue.
Yes, we will place the reliance. There is a power. This court has the power. This court definitely exercises power, my lord, for transferring one case to another, one district to another district. There is no bar. This court can do it, my lord.
No bar will not do. We have to show some explicit decision.
Yes, yes, sir. We'll place some decisions in this regards, my lord. And moreover, my lord,
Don't concentrate on the Article 142 and Article 220.
yes. But question is, my lord, only the nature of the case is to be looked out. Whether a citizen, he can be deprived from getting proper trial, because those people are traveling from Dhubri to Shivsagar. In every day, he along with witnesses, Gaupura, some witnesses, they are unable to pay, my lord. That is why they most of the cases we found earlier, ex parte proceeding was going on. So on that consideration, this could You cannot helpless, my lord. This court has the power by considering the nature of the case. In some cases, I find this noble court already passed an order transferring cash from Sibsagar to some order is there. And in another case, it has been rejected. That is why matter has been referred to this noble court. Whether this court can transfer the matter from another district to another district. That is why. In some cases, my lord. In some cases, my lord, already order has been passed. Transfer the case from Sibsagar to Dhubri. Matter disposed of.
That has been discussed.
Wait.
To discuss.
So, my lord, your lordship will look into the matter and will address the court in proper manner whether this court has the power under 226 or not. Difficulty is earlier. Only difficulty is earlier. There is a finance terminal, then there is an appellate terminal, then there is a provision for filing writ petition in single bench. Now directly people come to the division bench. So they could not able to do that from, my lord. So that is why this court cannot look into the matter, my lord.
Yes.
Not this, what my lord, senior arguing, my lord. This is in the statute. If they are not satisfied with the statute, they have the remedy for that, my lord. I'm not. So the legislature has consciously met the legislation, my lord, by not giving that power. When that power has not been given, appellate court authority is not given, my lord. When the transfer power has not been, this is in, my lord, consciously met. If they are not satisfied with that law, they can go for, definitely they have the remedy, my lord. I'm not on that. Other aspect, my lord, definitely I argue. Only one aspect, your lordship. Here in all these cases, your lordship fine. The factual aspect, their claim is that they are permanent resident of particular village area. And while they were residing temporarily for in some particular area, they have been referred there in that area where they were temporarily residing. Now, my lord, if we accept one aspect, because the investigation officer, while investigate during the time of investigation, they give a statement that I'm a permanent resident of that particular area. So if we accept that he's a permanent resident of that area, indirectly we are also accepting that he's a citizen of India. My lord, his citizenship is doubted.
What happened in those findings? You'll see that though the property might have stated before the investigating officer that is a resident of Karimganj, Dhubri, South Kolkata, wherever. But thing is this, you'll find a note that the property failed to place any relevant document to show his nationality.
Yes, ma'am.
Even if he is a resident of Dhubri,
Even, my lord, that
the property fails to place anything before the, that was
Ma-
why the investigating
Yes.
report in the note gives everything.
yes,
What are the documents placed, whatever is there. He might give father's name or family member's name.
whatever
he
there,
might,
my lord,
But the relevant documents to prove that he's a resident of
that area
that
is not
also are
not
filed
sub-
by the prosecutor. You see the notes
yes, ma'am.
of the
My point of argument will be on that line, my lord, only. First, my lord, because if we accept, my lord, that whether he is a resident of that Dhuburi or Karimganj or not, that has to be proved in the tribunal. If he can prove he is a permanent resident of that area and his relative he is the son of so and so, then his citizenship will be proved. That is the fact in issue to be proved in the tribunal. Unless and until it is proved in the tribunal, how can we accept that he's a permanent resident of that village or that area? So that on the basis that I'm a permanent resident of that area, so my case should be transferred to that area, cannot be accepted. It has to be proved in the tribunal first that I'm a permanent resident of that area. Then only, my lord, the question, if he's a permanent resident of that area, if it is proved, then the entire case will be proved. Unless and until it is proved that I'm a permanent resident of that area, that cannot be, the transfer on the basis that I'm a resident of that area cannot be allowed.
Thing is, on their issue came with, as brother has pointed out, whether
So that is in
power
one
to
aspect of the matter, my lord.
we can pass any order, the read court can pass any order, transferring the matter from one bench to another, one foreign tribunal to another, that's in the state law. That's like,
Secondly, my lord, if your lordship, if they, my lord, argue that I'm a permanent resident of that area, so it will be my lord, it will be beneficial for sir, or it will be easier for us to carry the trial in that particular tribunal where I'm residing. If that plea comes, there are cases, my lord, where the proceedings realize that I'm a resident of, my lord, West Bengal. I'm a resident of, my lord, the Uttar Pradesh. Then if he claims that my case should be transferred to Uttar Pradesh, my case should be transferred to West Bengal, then what will be the situation, my lord? So this aspect should also be looked into. Because they claims, my lord, sometimes they claims as your lordship has found numbers of cases, they are saying I'm a permanent resident of West Bengal, but temporarily I was residing in Jorhat. I have been referred in Jorhat. So if he claims tomorrow, my lord, suppose if he come and file a petition that this matter may be transferred to West Bengal because I cannot reduce evidence here, it's far away from West Bengal. So there is no provision. There is no tribunal in Malad West Bengal. There is no tribunal in Malad Uttar Pradesh. And in some cases, Malad, this is in fact this while in the division bench, in some cases, in fact, there is no pleading of transfer in these cases also. Then also it is only on oral argument, Malad, this has been referred. There is no pleading in some cases. There are no pleading at all that this matter may be transferred. Only on the basis of oral submission.
How many matters are there before us?
6 matters.
You
Sorry.
said that in few of the cases, there is no prayer for transfer. Or-
Yes, Malad. In fact, the edition serial number 1 itself, Malad, there is no prayer for.
No, in IA, we have filed a separate, in item number 1, we have filed a separate IA with a prayer for transfer.
can we file an IA?
My lord,
But sending the prayer,
my lord, that has been allowed. My lord, that IA has been allowed and
No, IA has not been allowed. IA is not disposed. Hello, question.
IA number 1643/2020, and there is some order on the IA.
Mm.
Which of these cases are pertaining to only the transfer of the proceedings?
Item 4, I
4 is only for transfer.
transfer. I make a
Because in the
prayer also.
first case which we have noticed is we are not going to the technically that prayer was not there. You have incorporated the prayer by an eye, that is okay. But first we have to be satisfied that you have made out the case regarding setting aside of the
Yes.
order and remitting back. And the question of transfer would come only if we remit the matter back.
Well,
So you have crossed the first hurdle. You have not crossed the first hurdle. But so far as I think Mr. Amit's case is concerned, item number 4, that pertains to only a transfer.
Yeah, transfer only transfer. It is pending there, not disposed of. We submitted our reply, but only we adjust to evidences. Only for transfer.
2, 3, 5, and 6 also pertaining to only transfer.
Transfer.
Only transfer.
my case originally, we challenged the ex parte decision.
No,
And,
suppose even if
subsequently
you
we
answer
filed
this,
an IA.
even if you answer this reference in the affirmative, then also, so far as your case is concerned, your case is to be heard again on the issue of whether you have
Yes,
been able to make out a case for interference.
Sitting on.
Well,
We have not heard, that part has not been gone into. Your challenge to the expert decision,
Right.
that first has to be set aside, matter has to be remitted back. And when remitting, the question of transfer may come in, if you are successful.
we file a separate IA for transfer.
No, transfer of a proceeding which has already been disposed of, it will not make any sense until that is made alive by setting aside the order of expertise.
Well, that can be, my lord, considered together, my lord, and the
Now, how
our
can
IA.
be considered together? Unless you cross the first hurdle and make out a case for interference with the expert order, the question of transfer will not even arise in your case.
Yes,
First, you
Yes.
have to satisfy
Yes.
us, make out a case for interference,
Yes.
get it interfered with,
yes, sir.
and at the time of remission, remitting the matter back,
Yes.
the question of
Yes, sir.
remitting to any other tribunal may arise.
Yes, sir.
Mhm.
Mr. Karim is here.
My lord,
What is your submission?
my lord,
Same case, I don't know.
he is with me, my.
What about
My senior them wrongly from
Doesn't-
other side.
Heard Mr. A.R. Sigal and counsel for the petitioner? Item number 1. WPT 73092. Mr. P. Rahman. Counsel for the petitioners. Item number 2, 3, 5 and 6. Number get up right. And Mr. Desimoti Nath. Counsel for the petitioner. WPT number 3, 4, 4. After a certain deliberation, counsel for the petitioners raised for short adjournment of the matter. Prayer allowed. List on 30/11/2023.
My lord, we need some more time.
Why?
At least, my lord, in the second week of December.
We do not know because the study is available as of the roster up only up to 8.
My lord, 30 will be 2 days, my lord.
You'll have 1 week full day, you
My
have
lord,
3 days holiday. Saturday, Sunday, Monday, enough.
30 December,
Huh?
13 November.
13 November.
I have some personal difficulties.
My lord,
At least, my lord,
better, my lord.
Attended yesterday night.
Well, let us try on 38 because there was a reference way back in June.
No.
This bench was not being able
Hello.
to be,
Hello.
not able to sit. Today is what, 23rd, 22nd?
Have a
More
week's
than a
time.
week.
You have holidays in between.
কত তারিখে है
30th November.
30
November, आज 24 तारीख. 1 week time is not there.
Okay, 30th.
My lord, some more time, my lord.
Lordship, I have some personal difficulties here, Lordship. Till 15.
See, there are a number of councils involved. This is a very larger issue to be involved.
Yes,
And constitution of the bench is not so easy.
Lordship,
It may be deferred by, we don't know how many times. From June, we are waiting for this bench to sit.
Right.
Today is the end of November.
এক সপ্তাহ টাইম ঠিক বেশি টাইম দিব না
এতদিন তো বুকে
5th.
my lord 5th
5th
December.
of December. First day.
Pray that this case be allowed to be withdrawn with the liberty to file afresh.
Mr. T.N. Srinivasan, Learned Counsel appeared for the petition on instruction raised for withdrawal of this writ petition. File against the order dated 11/09/2019 passed by Learned Foreigners Tribunal 5th Judge Court, Vishwanath, in FP case number 1055/2016, declaring the petitioner to be a foreigner under the Foreigners Act 1946. holding that she has entered territory of India in bracket Assam after the cutoff date of 25/03/1971. And further pray to set aside and quash the order dated 16/08/2022 passed by the same tribunal, dismissing the review petition number PNC /29 2016. It was filed by the petitioner hearing against the aforesaid order dated 11/09/2019. Anything else? Mr. Shiv?
My lord, I just need a liberty, my lord, to refile.
Petitioner is also seeking liberty to file application. Carry out petitions as stated, being not pressed, liberty as free.
I'm obliged, my lord.
Wait, please, your lordship. I'm praying for a listing of a unlisted writ petition on tomorrow, my lord. The petitioner is behind the bar since 31/10/2023. She is a 52 years old lady, lordship. So I may be allowed to list it on tomorrow, lordship.
When did you file?
Yesterday, lordship.
Okay,
Deeply obliged, lordship.
but it should be, there should not be any defect.
Lordship. Deeply obliged, lordship.
Please, your lordship, with the consent of from the other side, I'd like to state item 12. My senior is out of station. Lordship may fix the matter after a week.
Don't care about it. Okay,
Much obliged.
what's your good name?
Deeply.
On behalf of Mr. AI. After due verification. Submitted. After due verification. And information from the election commission. Submit. That. During 1965. The number 82 Morigaon Legislative Assembly constituency in the state of Assam. It was reserved for scheduled caste and scheduled tribe for the next instance. Yes. Tell us. Which is your link document?
Lordship, and see annexer A, lordship.
name of the petitioner father and the grandfather lordship. In the Jamabandi copy 1968 and 69 lordship. Page 12, Parnagular.
Yes, we have seen that.
Lordship, Annexer B, Lordship, 1965 voter list. Father name of the petitioner appear in the voter list of 1965 Lordship.
Then
Lordship 19, Annexer C, Lordship, page 16, 1970, name of the father of the petitioner appear, Lordship. Lordship in page 18, Annexer D, 1993, name of the petitioner is appear in the voter list, Lordship.
which year?
1993, Lordship.
Where is your written statement?
Lordship, page 15, Annexer H, 25, Lordship.
Which is your link document?
Lordship.
Which is your link document?
So I have annexed. The link document is 1968, 69, Jamabandi copy, 1965 voter list, Lordship.
Which document reflects your name along with your father? Which document reflects your name with your father?
Kindly see, Lordship, Annexer D, Lordship, page 18. Lordship, kindly see, Abdul Jalil, son of Monuruddin, Lordship. Voter list of 1993, Lordship.
Hmm.
And Lordship, voter list of 1997, Lordship. Here also, Lordship, appear my name, Abdul Jalil, son of Moniruddin, Lordship. And Lordship, Annexer F, Lordship, voter list of 2005, Lordship. Petitioner name is appear, Lordship, along with his father name, Moniruddin.
That is sufficient. As per the voter list of 1993, you're 30 years old.
Lordship.
So your birth year was 1963. So your name should have been in the voter list of which years?
From 1993, Lordship.
Why? It was 30 years in 1993. Why your name did not figure in the voter list prior to that? Definitely, your name along with your father would have been there in the voter list prior to 1993.
Lordship, I have to take instruction, Lordship.
Now at this stage, what instruction?
All the documents, Lordship, submitted during the submission of written statement, Lordship.
That's why I want to know from you. Sangma, Sangma, reply. Which is your link document? We are asking you again.
Lordship, Bhuta list of 1965 and the Jamabandi copy of
That shows that your
1969.
protected father.
And Lordship, kindly see the village name of the father of the
Is
petitioner,
that
Lordship.
enough?
In the Bhuta list of 1965, Lordship.
Yes, Mr. Pathak, tell us whether a voter list showing a Prosidi not along with his father, but protected father, whatever, son of his protected father, is that enough to prove the link document to establish?
No, Lordship.
Why it is not, why it is no? What is the reason?
The voter list is prepared for electoral roll, and the projected father along with his siblings, Lordship, it is if and voter list cannot be taken as a proof of citizenship or in case of, for that regard, Lordship, we have judgments of this honorable court, and it has not been considered as a link document, and more so there, as the learned friend is keeping reliance on the copy of the Jamabandi copy, and it is a Axonia Lordship. So the link of the projected father and the petitioner could not be established in this particular case, Lordship.
Mr. Counsel, is there any document to show your father and mother jointly in a voter list? And you, and along with your mother, in a voter list?
No, Lordship.
No. In that case, in your written statement, where you have stated in which year your father expired, where you have stated the name of your mother, have you stated in your
Lordship.
written statement? You are totally silent. Who is your mother? So, Lekha, part Mr. M. Alon, counsel for the petition. And I must. That forward. Not a- what is going on. Also hard stuff. And it's the council from department. Was 2, 4, 2 and 4. Mr. P. Sharma, excellent senior professor for the and Mr. AI. By in order, the 2101/2019, passed by learned member foreigners tribunal number first Oregon, some in case number F dot P dot 459 of 2001. Being referred by the Superintendent of Police Order Oregon by police reference case number 79 of 2010, dated 22/02/2010. After hearing what is declared a petitioner to be a foreigner. Under the Foreigners Act 1946, who had illegally entered foreigner plus illegal migrant into the territory of India to become Assam on after 25/03/1971. Answering the reference in affirmative, since the petitioner failed to prove in evidence regarding his family linkage, that is born out of genuine Indian values. Peruse the relevant documents. There is the impugn order dated 21/01/2019, and we propose to filed on 17/03/20. And we propose to peruse the relevant records. Outside case number FP of 459 of 2000 of the Foreigners Tribunal of the past before we proceed further. Call for the record of the correct. Petitioner selected before. Morrigan, Honor 60. Leave this matter immediately, leave this matter for motion immediately on this. The relevant records from the concept first.
Hello.
May please your lordship. Reputation as initially appointed as statistical officer as per the recommendation APSC. Thereafter, he promoted research officer, deputy director, and again now he joint director. What happened actually in the year 1970 service rule, as per the in his entrance service rule, service the service rule, there is course statistics, mathematics, economics, and commerce. Commerce subject is deleted as per the amendment of the 1995. What happened? Director of economic statistics is advertised. Your lordship may kindly page 50 to 50 to A to G. Legible copy already submitted. What happened? I am going to be deprived.
What is the rule? How it is supposed to be filled up? The post of Director of Economics and Statistics.
So rule said 95. The commerce subject is deleted. 95. In the original service rule 1973, commerce says as per this service rule I was appointed. But in this connection, all joint director are filed a representation to the government. And thereafter, the Director of Economics and Statistics, page 91. Your lordship may kindly peruse the page 91. They send the proposal to amend the rule. Page 91.
Just a minute.
Lordship,
Only felt ill and
Okay.
he has to be hospitalized at MK. He's in ICU.
So total weight.
That's why we are getting the report. Okay. He was not feeling well since yesterday. Suddenly.
He's here.
Yes.
He's here. He didn't got it.
He is in
Well,
Guwahati. He has a bench yesterday.
Yes.
But today morning he was more ill, so he has to be shifted to hospital. And he's in name care of.
Here.
Let us see. Is there any rule? Because earlier there was a 309 rule.
My lord.
So whether the subsequent provisions have been amended in that case with regard to this mode that you have advertised.
Now that advertisement is as per rule which was amended in long back in 28 years ago. I think it is 2019,
95, I believe.
95 amendment. So 95 amendment has been challenged right now.
Whether after 1995,
My lord.
that it was a 309 rule,
My lord.
whether any rule has been, that 1995 rule has been amended.
No, that amendment, my lord, government.
Your Lordship, send a proposal, page 91.
That part, my lord, can be taken care of by the government, my lord. But so far, 95 rule, his case is there in 73, it was there, 95, it is not there. So in 95, since 95 till today, whether any other amendment, my lord, that we have to look into.
Just tell us one thing. This is a draft rule, right? This is a draft rule.
Draft rule.
Has it been amended?
No, my lord, send the proposal to the government.
So
What the cabinet also,
as per the amended rule, the draft rule
Draft.
not yet been amended.
you not amended,
Is there a requirement of subject of commerce
subject of comment,
required?
required.
But in the 1995 rules, was there any requirement of subject of commerce? Not required.
No, your Lordship, I am going, when I was appointed as per 1973, as per this service rule, why it is a deterrent? It is a vested interest. It is a ultra virus. So I am, citation, there is a one, I am going to file.
Listen, let us, please show us the relevant 1995 rules for filling up the post of director.
Huh.
Show us the provisions in the 1995 rules for filling up of the post of the director. Which provision is applicable for filling up of the post of director as advertised by the APSC?
No, your Lordship, it is now it is the ultra virus. So
Show us which provision. Which provision? Was there any provision for filling up the post of director in the rules in force?
now at present, 95,
Page 62.
Which rule is applicable?
now 95 rule is applicable. The original
Which provision?
Section 7, page
section
62.
7.
Page 62, your lordship. Kindly. Problem is that, my lord, the copy supplied to us is, my lord, not really visible, my lord. Visible as if
That rule.
I am giving.
95, no, 95 rule. 95 rule. 85 rule. 95 rule. Hmm, 74. No, 95 will from behind enemy. Listen. And 95 will from toward. Any complete rule from listen in 95.
No, the complete.
Yeah. Complete rule from the assay. Human presentation.
Yes, sir.
It's like a minute. 84.
84.
I'll say 85 to have copy.
That is control provision.
85 is subject to and then on
Itu no. Itu cukup. Principal rule 10 असेल ना. At least second class master degree in economics, statistics, and mathematics. Originally good case. My lord, page 65, my lord. Qualification for post of direct recruitment.
That was in 1973 rules. It was
No.
amended in 1971.
97.
1991. Sorry, 1991.
91.
Then come to page number 78. '77. Down below. Rule 5 was amended.
Yes.
But direct recruitment is always there.
Yes, it is.
What is the amendment mean?
The amendment to rule 10, my lord, your lordship will find page 86, my lord. In the principal rule, in rule 10,
sub rule so and so, coverage so and so. After during a university, or at least second class master degree in economics, statistics, mathematics of a recognized university or its equivalent. So that, my lord, commerce is deleted.
Commerce is deleted.
So that is amendment that was that amendment in 1995. So in pursuance to that amendment, my lord, government sent a requisition to us, my lord, accordingly. we evaluate. That is amendment of Rule 10, my lord. Earlier it is in Rule 10. Page 86, my lord. Amendment portion is page 86, my lord. What do you put it? It is. Page 65 is the original and page 60, 85, 86 is the amendment, my lord.
Please come to page number 85B.
85B.
Amendment of Rule 5, serial number 4.
No, that is not visible, my lord. That's why that is completely dark in my.
Okay. Amendment of Rule 5, it is there in page 85 probably. There is a type copy.
No, there is no type copy has been given, my lord.
You have not been provided a type copy.
85 is. 85, type copy, type copy. 85 is, type copy.
The copy of Mr. Mahanta.
Type copy.
85.
85.
Oh, yes, my lord.
And time.
Subsection 7, clause 7, the figure.
No, it is with regard to amendment of Rule 5. Rule 5 relates to the 1971 rules, relates to that 73 rule relates to director. Now, in the principal rule in Rule 5 that relates to 73 rules, 1 clause B of sub rule 5. How it's related to the director? It has nothing to do.
Now, you also my another submission. Now,
Can you tell us? Because in the 1973 rules, page 59, Director of Economics and Statistics, it is clearly provided, appointment shall be made by direct recruitment through the commission. In the schedule, there is no such specification regarding the qualification or eligibility for the post of director in the principal rules. Thereafter, the amendment came 1991, page number 77. Is 78, category 1, appointment shall be made by direct recruitment through the commission. Where is the eligibility or the required qualification for the post of directors in the 1991 amended rules? Yes, where, in which particular amendment?
1995 or 1995. Page 91. 1985. Subject the means of economics, statistics or mathematics. 85. Page 85. 85.
19 commerce class. Originally rule 10 है यहाँ पे. Originally rule 10. No, 72. No, so. 81.
See, basically, the principal rules of 1973, the post of director was to be filled up by direct recruitment. Right?
Yes.
However, in the rules, we have not seen the qualification of the director, but okay, that 73 rules, Rule 5 was amended in 1993, 1991. Wherein Director of Economics to be filled up by direct recruitment through the commission. It is clear. Whether it is in 73 rules as well as the amended rules of 1991.
91.
After that, the rule was again amended
In 95.
in 1994. It's a 309 rules.
309.
Now, in that 1973 rules, Rule 5 was amended. Now take page 59 in your hand, in one side, and 85. You will see of Rule 5 how it was amended. There is no mention about Director of Economics and Statistics. It straight away goes to Rule 5, Sub-Rule 5 of Rule 5 of Clause B. The first amendment was Clause B of Rule 5, Sub-Rule 5. Clause B of Sub-Rule 5 that relates to research officer and programmer. Clause B of Sub-Rule 6. So Clause B of Sub-Rule 6 and Clause B of Rule 5 both relates to the appointment of research officer, programmer, and statistical officer, assistant programmer by direct recruitment, which has been amended by this 1991, not 1991, this is by, yes, 1995 amendment. So after Clause A of Sub-Rule 5 and after it was amended that in the Sub-Rule 7, at Clause A, if you read, the figure marked 50%. That was for promotional quota in sub-rule 7 of Rule 5, the principal rule. It has been enhanced to 70%. And the direct recruitment has been lowered to 25%. That's the amendment of Rule 5. Now, where is the discussion about the subjects? In which rule? Which rule relates about the subjects? You are
Rule
saying
10, Rule
commerce.
10.
Where?
Rule 10, qualification for direct loan. Now he is
For director, qualification for director.
direct loan.
Rule 10.
Rule 10.
Of which rule? The amended rules,
I mean, the-
Yes, madam.
1995.
Original rule 10,
Yeah.
and Rule 10 has been amended in 1995. The earlier the commerce is also one of commerce graduate also one of the qualification. In 1995 rule, that commerce section has been commerce is deleted. So since 1995, my lord, it is going on that way. Now, my lord, when his term comes, my lord, now come before this honorable court, that rule is bad, my lord. He says that is his case, my lord. Rule of 1995 is bad. Because he is commerce graduate. So he is not eligible for that director, post of the director.
Commerce-
So now
commerce
he is
deputy.
challenging that 95 rules, my lord. That's why it is before the division bench, my lord.
Mr. Mahanta,
Probably that is his case, my lord. My lord.
this Rule 10 was amended only in the year 1995.
My lord. No, so far is director is concerned. Page 86, my lord.
Yes. Just tell us one thing.
No, your lordship, I'd like to submit one important
You
matter.
were initially recruited as what?
Initially appointed as a statistical officer. As per the
Statistical officer. just a-
statistical officer, not
Just a-
research officer. Then he come to research officer, deputy director, then come to the
Which
joint
provision
director,
relates to the statistical officer?
statistical officer. Initial appointment. Now, your lordship, I like to submit one thing. In other state of India,
We are not in other state, we are in Assam.
in even Mizoram also, director post is state commerce. I am annexed here. Maharashtra and Haryana. Director post होता है
Mr. Mahanta.
My lord.
See page 66, page 60.
Page
60. Statistical officer. oblique assistant programmer.
Yes,
Petitioner is saying that he was directly recruited.
Directly executed APAS or APSC recommendation.
Now, there are two processes of entering there. Statistical officer, assistant programmer, either by promotion from category 7 or from direct recruitment. What was the qualification when you entered the service?
MCOM,
Where is that qualification
Commerce.
prescribed in the 73 rules? Where is that qualification prescribed in the 73 rules?
commerce subject was at that time commerce subject.
Which rule? What was the qualification for recruitment to the post of statistical officer?
1970. Degree of University Mathematics, Statistics. It's 65. 66.
65,
66.
66, where?
For the direct recruitment of post of research
Clause two.
officers,
Research
clause, at least second class master degree in statistics, mathematics or commerce of a recognized university. For the direct recruitment of post of research officer.
Research and statistical both.
Clause 2 admits research and statistical officer.
Officer. Initial and
Okay. Now, that was deleted by the 1995 amendment. Please come to rule. Twenty-five, page 71. Read rule 21. Sorry, 25.
Relaxation void of government satisfied. Recruitment. Condition.
So you have the relaxation clause. You should have applied.
Yes.
At the time of your recruitment as a
Yes.
statistical
Commerce is
officer,
there.
there was the requirement of commerce.
Commerce.
So with the commerce, you have entered into a service.
Yes, ma'am.
Now you have become eligible for the post of director.
Right.
You have the requisite qualification. But by way of amendment in the 1995, the commerce subject has been deleted as a requirement from post of director. When the relaxation clause is there in favor of you, you should have applied for relaxation. Why you are here?
No, advertisement, your lordship make advert.
Why you are here? Definitely. That's why the relaxation clause is there. You have just now read what is there in the relaxation clause.
Lordship, as per advertise, I cannot apply.
You cannot apply. That is why you have to seek relaxation. That is why you have to seek, that clause is there only for your benefit. Instead of coming here, you should have applied for relaxation.
To the government and with the approval, he can apply. Think it over.
Why you are here?
Just because he's challenging the rules, my lord, that's
That
why.
will not help you. That is because the act is sufficient.
আমি চিন্তা করে style of যদি আপনার interview বহিবলে লাগে
No, now he is a senior most.
Whatever. What is the last date?
Last date is already over. Now a process is going on. So it is a matter, so it is a urgent matter.
How can we interfere at this stage? When the act provides you sufficient help is there to you, you will not interfere.
No.
You will not interfere.
The matter is alter virus also. So I am
Just, why do you are saying ultra-virus?
No, no, not I am going to the for amendment.
See,
Yeah.
we'll dismiss it because Act is sufficiently empowered to give you the help. Instead of obtaining that relaxation, you are here. You have those provisions.
Observation. Virus, so virus.
So was the virus.
Ah.
Where is the virus? Only because the commerce has been deleted, that is the reason it is virus. And you are not eligible now. In the year 1995, that was amended, you were silent. Now, as because you are not eligible because you doesn't have, commerce is not an eligible degree for the post of director. Now you have become vibrant. The act and the amendment is bad in law. That will not do. If some amendment is there and an amendment has brought some difficulties for you in your promotion, you can always seek relaxation, and that provisions is there in the act, in the rules. Why court should interfere? Will not interfere. Advertising the court. Yes. You better today itself go and file before the commissioner for relaxation.
No, your lordship may kindly this case on fix on 20, 28, 29, 29. May kindly fix on 29.
Mr. Mahato, what is the state of the?
No, already my lord, last date is
Over.
over on 1/9, probably 1 as per advertisement. 39, yes, 39/2023. So he has to apply to the government, my lord. Government can relax, my lord. That power,
Whatever you indicate, I think.
my lord. Yeah, but if any approaches honorable court after the last date is over, my lord. But regarding my lord interview, what happened, I don't know, my lord.
No, now under process.
Yeah.
Not Mr. M. Talukder, learned counsel appearing for the appellant. Sorry, petitioner.
Petition.
Repeat, and Mr. P. Sharma, additional senior government advocate Assam. For the response number 1, 2, 3 and 5. Also heard Mr. T. J. Mahanta, London Senior Counsel. Assisted by
And P. Sharma, Lordship.
P. Sharma, London Counsel. For the respondent, Assam Public Service Commission. Response number 4, Assam Public. Assam Public Service Commission.
Relaxation.
Your next promotion is what?
Next for the additional the director.
Where is the qualification for that clause 10? 95 rules. Of additional director. You are eligible for additional director.
51. Additional director, appointment made by the promotion for the page 59. People for the eligibility having rendered less than 5 years service in category 3 and total of 21 years service qualification.
So without becoming additional director, you can become a director.
Additional director.
No.
Qualification.
Director বিষয়ে আর কি পোস্ট আছে?
Additional director.
Director বিষয়ে additional director কেন?
No, director, additional director.
Director আগত দিছে।
So now he's a joint director, next promotion additional. director.
What are your subjects in your graduation?
Graduation, economics, statistics,
And
and also commerce. Now, master degree in commerce.
please come to page 65.
Which 55. Qualification of direct.
Kindly read 1A and or.
At least second class master degree in statistics, mathematics, economics, commerce.
Kindly read the whole.
Qualification for the direct recruitment. For the direct recruitment to the post of the director of the economics and statistics, a candidate shall be the following qualification. At least the second class master degree holder in statistics, mathematics, economics, and commerce from the recognized university. A degree recognized university, mathematics, statistics, economics, commerce in a subject and a diploma recognized by the government obtained after at least 2 years postgraduate training in the statistics. Doctorate or other research degree in statistics, mathematics, economics, commerce is desirable. Not less than of 10 years service of the statistical works, investigation, research is a government department or commercial concern of report or in conducting and guiding the research in a statistic in university or institute of obtaining research as evident by the published work. Administrative inexperience for not less than 5 years in responsible capacity. Is notwithstanding anything contained in the rule 9, a candidate shall not be on the first day of the year in which the advertisement is issued less than 35 years and more than 45 years.
So relaxation will come, will be benefited by how much? 5 years?
5 years.
So 50. You are 57 years.
Yes, ma'am.
Will you be eligible?
Yes.
Without first eligibility, question will not come.
My lord, definitely.
Now, if you are having your graduation with these 3 subjects, you are otherwise eligible. If you are saying that you have these subjects in your graduation, right?
Yes, ma'am.
Then you are eligible. If you're permitted by age. What is your qualification in your graduation? If you have degree out mathematics, statistics, economics, or commerce. So if you had the statistics, you are eligible.
No, the master degree in
There is an
commerce is
or. That's why we have asked you to read page 65 again. Only read page 65. There is a or. Either you must have a second class master degree in statistics, mathematics, economics, or commerce. You are having a second class master degree in commerce. Good. That is first part. Or if you have a degree of recognized university with mathematics, statistics, economics, or commerce. If you have these subjects, you are eligible. What was the subject in your degree? Do you have the degree certificate or mark sheet?
No, I'm not submitting here the degree certificate, only master degree,
Do you have,
not available to me now.
Mr. Don't know.
No, my lord, actually regarding his personal, I do not know, my lord, even in our this petition, my lord, all the papers are, my lord, are not readable.
legible.
That's why it is be problem for
No
us,
difficulty, see, by that 1995 amendment,
my lord.
only the commerce
Is
part
the-
has been
Only commerce part has
Not
been,
deleted.
Rule 73 very clear, relaxation is there.
is there. So,
Now, mostly now the two things. Here, either second class master degree in
or
these subjects, or you have a degree from recognized university in these subjects. Oh, you didn't have the diploma
No, I don't.
because there is a requirement a diploma. If you are a
Diploma.
degree holder,
Hmm.
you must have a diploma recognized by
Is to be
government
45.
after at
Apna
least 2
work
years
man hall.
postgraduate training in statistics.
Which
That
is-
is condition precedent. So
My
you
lord,
cannot have those things.
I don't know even otherwise he is eligible or not, my lord, because as per the affidavit, his age is 57.
Otherwise
57.
not eligible,
But his 50, his maximum age is 45, as per the advertisement.
but it will be relaxable for.
No, electable, my lord, that has to be, my lord, another, he has another barrier also, my lord. For that, my lord, he has to apply to the government for relaxation of the age. But here, my lord, actually, he is challenging the rules, that's why, my lord, we see the rule only, my lord. Regarding his personal data, I do not know, my lord. His case is that in initial NTA, commerce is the qualification. Now, my lord, in the final post, commerce is not been there. So in that case, if there is a relaxation, my lord, he has applied to the relaxation, government will relax and he forward the application to us. But if he challenge the rule, my lord, then, my lord, then government will answer, my lord. If whether it is valid, it is, my lord, otherwise or not, my lord.
That's good.
Even on rise, my lord. 57.
On 24/08/2023, the Assam Public Service Commission issued the advertisement number 22/2023. Whereby the post of Director of Economics and Statistics under Transformation and Development Department earlier known as Economic and Statistical Department. Was published. Wherein
No. Regarding, let's see.
a post of You have not given the complete advertisement. Do you have the
Yes.
complete advertisement?
Yes, my lord, I'm submitting complete advertisement.
Where is that?
Yes, yes.
This 50.
50A, B, C, D, E, F, G.
No, সেইটো আছে এই যে
Purpose of NH.
সেইটো নিউজ পেপাৰ পৰা দিছে নাই নাই সেইটো
What happened with your representation of 2019?
2000. Yes, no? Yeah? 50, no?
Page 55.
Page 55. Page 55. Page 50.
What happened with this representation?
Representation prepared for consideration of master degree in commerce as one of the.
What happened? What is the outcome?
No, I know. Already filed a representation. There is no any outcome.
Why you
That
have not stated before the single judge earlier?
That is to the government.
Mr. Mahanta,
My lord.
in this advertisement, where is the age?
No, age is 45, but my lord, on-house candidate, there is a relaxation in the rule itself, my lord. Age, my lord, minimum 35, maximum 45. But my lord, if your lordship go rule 10, my lord, your lordship kindly see, age, my lord, page 65, age, clause 6, my lord, page 65 plus clause.
Right, right.
Is notwithstanding anything contained in Rule 9, the candidate shall not be on the first day of the year in which the advertisement is issued less than 35 year and more than 45 year of age, provided that the candidate belong with the service, there shall not be upper age limit. So that benefit he will get. Because he will proportional through his, my lord. But one thing, my lord, if he is not challenging the rules, my lord, that is a matter of single match, my lord.
We'll make it clear. Saying that
More timing to find one.
where is the advertisement, full advertisement?
50. 50.
See, where is the remaining pages?
Your lordship 58 is there.
We do not have 58 to that in your petition.
58, that is only paper publication, here's my lord.
After annexure G, you have annexure H, page 51. Where is the remaining page of the advertisement?
I have already.
You have filed this way. You should have thrown it out.
Can I get part?
Wherein your petition is incomplete. I'm sorry. Extremely sorry. The additional qualification has been prescribed as follows. Qualification for the state post. Order in the said advertisement. Age of vacancy. For the post advertised. As per the said advertisement dated 13th September. closing date for online application was 30/09/2023. And the last date for payment of application was 0/10/2023. The petitioner was initially appointed in July 1992 on 23/06/1992 as a statistical officer, Department of Data, Arts File. Please take your seat, Mr. Talun. Having second class master degree in commerce. And he joined his service on 11/07/1992. And since that he is serving such and such department. Present number. The petitioner is presently serving as Joint Director of Economics and Statistics. In SAID Transformation and Development Department. The by waiver and amendment in the year 1995, the rule 309. The requirement of qualification for the post of director as specified in the principal rule of the Assam Economic and Statistical Service Laws 1973. The rule under Article 309 of the Constitution, regulating the recruitment in the condition of persons appointed to the Assam Economic and Statistical have to obtain at its written. The qualification for recruitment to the post of Director of Economics and Statistics of a candidate was page 62. Or the subsequent amendment in the 1995 that came into force commerce has been deleted. From the eligibility criteria. Eligibility of the qualification. Eligibility criteria is a qualification for direct recruitment. And as such, the petitioner has become ineligible to apply for the post of Director of Economic Statistics in certain department. Hence, this petition by the petitioner challenging the various of said amendment of Rule 6. Amendment of Rule 10 of 1973 by way of amendment of 1995. Like amendment Rule 6. Within bracket, small comma. Petitioner contended that when he joined the service, he was a second class commerce master degree holder. And as such, he should be considered for the post of Director of Economic Statistics. At that time on 24/08/2023. From the said 1973 rules appended to this petition, we have seen that Rule 25 provides for relaxation, which reads as follows. Page 71-72. Or for us. And the said relaxation clause is still in force as has not been amended yet. It is also seen that the petitioner earlier filed a representation before the additional Chief Secretary Government of Assam. File number EES/PF/25/2019/5 dated 08/04/2019 for consideration of his master degree in commerce as one of the subject for selection of candidates by APSC for recruitment to the post of Director of Economics and Statistics of Assam. Annexer's date of his petition. Thereby seeking relaxation. And the through the Director of Economics and Statistics. And the Director of Director of Economics and Statistics of Assam, file number DES.75/2020 ESTT establishment or E-Capital DES public 18 dated 22/11/2022. Forwarded is a representation of the petitioner to the Additional Chief Secretary Government of Assam, Transformation and Development Department. However, on being inquired, Mr. Talukder submitted that said representation of the petitioner dated 08/04/2019 still pending for consideration. Not yet disposed of by the authority concerned. List on first of December. And on the same date, the Additional Secretary Government of Assam, Transformation and Development Department, Respond number 1, as well as the Principal Secretary Government of Assam in the Transformation and Development Department shall apprise the court about the status of the representation of the petitioner dated 08/04/2019, as well as the forwarding dated 22/11/2022 of the Director of Economic Statistics pertaining to the relaxation to be given to the petitioner in terms of Rule 25 of the 1972 rules. For this status of petitioner shall serve extra copies of this writ petition to Mr. P.N. Sharma, Learned Standing Counsel. Sorry, an additional Senator Assam representing the respondent numbers 1, 2. 1, 2, 3, and 4, 5 during the course of the day. Mr. Sharma, state has a long holiday up to Monday. The matter is fixed on Friday. So give us the status of those two representations of the petition.
Deputy.
My lord, this petition is directed against the SARFAESI proceedings, lordship. Here, the fact of the case is this, lordship. The petitioner number 1 had taken a overdraft facility of rupees 70 lakhs from the respondent bank, lordship, and the account was going regularly. All of a sudden, lordship, the bank had issued a notice under section 13, subsection 2 of the SARFAESI Act, lordship, for that your lordship will get at page 44, annexure 3. Annexure 3, lordship. Page 44, this is the notice dated 28/6/22 issued to Atawar Rahman, who is the borrower, lordship. We refer to letter number so-and-so convening sanction of the various credit facilities and the terms of the sanction pursuant to the above sanction. You have availed started utilizing the credit facilities after providing security for the same as hereinafter stated. The present outstanding in various loan account, facility accounts, and the security interest credited by such liability are under, lordship. Your lordship may please to note down the account number of the petitioner number 1. Last figures are 201, lordship, and the sanction amount 70 lakhs, lordship. And then, lordship, here may come to the next page. Para 2, consequent upon the defaults committed by you, your loan account has been classified as non-performing asset on 26/5/22, 20 in accordance with the Reserve Bank of India directive and guidelines. In spite of the repeated requests and demands, you have not repaid the overloan loans, including interest therein. Having regard to your inability to meet your liability in respect of the credit facility duly secured by the various security mentioned in para 1 above and classification of an account as a non-performing asset, we hereby give you notice under subsection 2 of section 13 of the Securitization and Reconstruction of the Financial Assets and Enforcement Security Interest Act 2002 and call upon to pay in full discharge your liability to bank aggregating to rupees 69,48,528.59 plus unpaid interest as stated in above within 60 days from the date of the service of the notice. We further gave you notice that failing payment of the above amount with interest till the date of payment, we shall be is free to exercise all or any of the rights under the subsection 4 of section 13 of the said act, which please note to please note that interest will continue to accrue in the rate specified in para 1 above for each credit facility until payment in full. We invite your attention to subsection 13 of section 13 of the act, in terms of which you are barred from transferring any of the security assets referred to in part 1 above by way of sale, lease or otherwise, other than in ordinary course of business without obtaining our prior written consent. We may add that non-compliance with the above provisions contained in section 13, subsection 13 of the act is an offense punishable under section so and so. We further invite your attention to subsection 8 of section 13 of the act, in terms of which you may redeem the secured asset if the amount of dues together with all the costs, charges and expenses incurred by the bank is tendered by the borrower at any time before the date of publication of the notice or public auction, inviting questions, tendered private relative. Please note that after publication of the notice as above, your right to redeem the security asset will not be available. My lord, this is the first notice, lordship. The lordship here, this
Your lordship, there is a settled position of law, and there are so many judgments, even of our Honorable High Court's division bench. And in this petition, the basic thing is in challenge is a possession notice under section 13(4), and that is the efficacious remedy is available under section 17 before the debt recovery tribunal.
my lord, here
So
the dispute is this, lordship.
The prayer is only at page number 35.
11. Possessory notice
Possession notice, nothing more than that.
that we have seen in the prayer.
Yes, it is only the possession notice dated.
No, lordship, here, what happened, lordship? Others accounts has been shown, lordship, in my account, lordship, of which, for which against I never stood as a grantor or never took any loan, lordship. If a series of letters were filed by the petitioners before the bank that we are ready to liquidate the loan amount, and kindly confirm that after deposit of the loan amount, you will return our title document. Lordship, lordship, may I please to peruse the
Page number 35 is the prayer, Your Honor.
no, prayer is okay.
And as far as the dispute is concerned regarding the payment or the BG account has been taken over or some extra amount has been charged by the bank, all are matter to be adjudicated by the DRT.
No, no, lordship, here the question is this, lordship, the amount which are not disputed, even today, lordship, I am ready to deposit 10 lakhs within 10 days, lordship. Till then, I may be protected, lordship.
What is the principal amount?
It is 58 lakhs.
No, that is with interest rate.
Actually, as per their statement of account, lordship, the amount, balance amount is only page 125, lordship. This is the statement of the bank. Page 107, lordship. Page 107, lordship. This is the last part of the statement. 54 lakhs, 50,723.
Out of 54 lakhs, 50,000, 35 lakhs, 37,000 is a loan amount, interest amount.
Including all,
No,
principal
no,
interest.
35 lakhs is not an interest.
Lordship, the balance payable by the petitioners are only 54 lakhs, 50,723.
It is only 54 lakhs pay. It is only 54 lakhs.
Yes.
And your lordship, they have raised a dispute only in regard to somewhere 8 lakhs amount. Remaining is admitted amount.
Now, lordship, will please to peruse
We have
the,
seen that 8 lakhs an amount has been taken in excess. Pay the same amount. After all, it's a public money.
no, now we are ready to deposit 10 lakhs,
That
lordship.
is, we are not, here we are not any, putting not any.
No, no, your lordship, will please to peruse
You want
the,
any order from the court not to act upon the notice? You deposit the remaining amount minus 8 lakhs.
no, I will deposit some of the,
Deposit before 38th of December, 38th of
no,
November.
no, lordship. Lordship, may be pleased to pay with some letters, Lordship.
We are not going to that aspect. See, first of all, the law is well settled. In fact, my sister is one of the judgment.
Yes. Lordship,
So,
in the,
We are not,
just
you have the remedy. But if you
one
pay-
annexure, your Lordship may be
if
pleased
you
to
pay,
pay.
we'll consider. That
Then
only I
Lordship,
can say.
I may be allowed to pay in 6 installments.
No, that should have been long back. Now this is after the that notice.
Lordship, the
Number
amount which
11.
is not payable by me that they are demanding, Lordship, may be pleased to peruse the annexures, Lordship.
Your Lordship, they may agitate the point in section 17 application.
That is not the
Show
alternative.
your deposits after taking the,
Pardon, Lord.
show your deposits after taking the loan.
I have deposited, Lordship.
Show your deposits.
Yes, Lordship. That your Lordship may be pleased to, I have paid, Lordship, more than 28 lakhs 50,000. I had deposited, Lordship. Your Lordship may be pleased to come to page 15. Page 15, para 23. Page 15, para 20, that the petitioner had deposited the following amounts. That
As
amount
of now,
shown.
how much you have withdrawn? As of now, how much you have?
Now
withdrawn?
thereafter, I did not, after deposit of 28 lakhs 50,190, page 16, Lordship, total amount, I have not withdrawn any single paisa.
Your Lordship, on 28/6/2023, we have issued a notice under section 32. Thereafter, the debit has been freezed because that means the amount cannot be withdrawn. And thereafter, the writ petitioner has deposited 22 lakhs 50,000. So their balance has come down from 69 lakhs to somewhere 46 lakhs. And that too, the last payment was
My-
made on 2/1/2023. And accordingly, since the guidelines is there for 90 days, after 90 days, we have again
Lordship,
declared NPA the account.
Lordship, may please to come to page 18, Lordship, para 26. Only there are 4-5 items which are not payable by me. Page 18, para, the respondents are also shown in the statement of account BG charges as follows. So BG charges 1,51,631, which I never obtained any BG, Lordship. I have made categorical statement on oath that never I obtained any BG. So the question of paying the BG commission does not arise. Then similarly, Lordship, para 27, that the said statement account respondent has charged recovery amount from account number so and so, last 3 figures 138. My account number is last 3 digits 201. So how I will be responsible for paying this amount, Lordship, which total comes to next page, Lordship, page 19, 3,72,417. I wrote series of letters. I am not responsible for the liquidation of the loan of the other person, Lordship. Your Lordship, please to pay the then other things are, Lordship, that
These are all
Lordship, may be
question of
pleased to
facts,
come.
Your Lordship.
Is 21,
Mr. Singh,
para 33.
the submission made on behalf of the borrower, is it correct?
No, Your Lordship. These are all disputed, Your Lordship. And these are not the part and parcel of 58 lakhs also.
Lordship, this can be simply solved that I may be given opportunity to file my representation and the bank may furnish the documentary evidence that I had taken the BG.
It is already pending before the DRT.
Yes, they can
Then-
take.
No,
some days,
the
Your Lordship.
BG matter is not pending, Lordship. In the 32 notice, there is no averment regarding the amount of the, which I have already pointed out, Lordship. Lordship may come to page 21, para
They cannot
33.
show this
And
amount
let
in
me
the
complete,
statement of
Mr.
account.
Sharma. Page 21, para 33, that the petitioners are ready and willing to pay the actual amount payable by the petitioner to the bank. But the bank has been asking the petitioner to liquidate the TOD, means temporary overdraft, of account number 254 of MB Construction. I am not connected with any MB Construction. I never stood, petitioner never stood as a grantor of MB Construction, Lordship. And they are demanding this MB Construction account more than rupees 3 lakhs, Lordship. Similarly, Lordship, Lordship, may we come to page 23, para 38. Page 23, para 38. That the bank has illegally deducted total rupees 7 lakhs 24,101 as BG charges, loan recovery and case withdrawal, which cannot be recovered from the petitioner. So Lordship, if a direction is given to the bank that the petitioner will file a representation for deducting the illegal amount from the statement of account, and whatever amount will come, Lordship, will pay immediately. Lordship will please to peruse the documents which I have seen, because the petitioner want to close the account, but the bank is not allowing me to close the account, Lordship. Page 85, Lordship. Page 85, Lordship, Annexure 6. Heading is subjecting request to close the CC loan bearing account number so and so in the name of the Atabur Rahman, and arrange to release the land documents of the undersigned kept in your branch in connection with sanction of the said letter. With reference to subject cited above, I would like to inform you that we had given guarantee in 2018 for term of 1 year for sanction aforesaid case credit loan backed by equitable mortgage of land, and had submitted our land documents in your branch. We are surprised by seeing that you have not taken recovery measures against the borrower for recovery of the NPA amount, and neither has been reviewed nor arranged to release our land documents by closing, liquidating the aforesaid CC loan amount after 3 years. That as per discussion made with you at the office chamber of your regional head, on 2/8/23, we the grantor are going to liquidate the aforesaid CC loan account by depositing the ledger balance book debts amount as full and final payment, and have submitted this letter before you. We therefore request you to kindly arrange to issue a letter of confirmation of my offer, and also confirm in your letter that after receiving the deposit of the loan amount of the aforesaid CC loan, you will release our land documents and deliver the same to the landlord undersigned at an early stage. This type of letter was also given, Lordship, by Annexure 7, page 86, similar repeating the same question that the grantors are ready to liquidate the loan. Then, Lordship, the page 87, third letter was given that they want to close the CC account by paying the amount whatever legally payable by the borrower and the grantor. Then, Lordship, see the conduct of the bank, Lordship, Annexure 9, page 88, letter dated 17/8/23. This is the letter by the Bank of Baroda. We refer to your letter, this sentence regarding request to close NPA account number in the name of Atabur Rahman and release of the land document. In this connection, we had already communicated you about the meeting held in Regional Office, Bhangaghar, Guwahati on 2/8/23 with Mr. Muslim Ali, our letter number so and so. We dictate that the bank will release the documents of the mortgage property of account number so and so on deposit of full amount, and closing the account of account number last 3 digits 201. This is my account also. And TOD amount in connection. What is the T of MB construction? I have no connection with the MB construction. What is the amount standing in the account of the MB construction, Lordship? Nothing has been specified. See the vagueness of the letter. So how I can deposit, Lordship? And then, Lordship, this time again by Annexure 10, page 89, Lordship, again the bank has written same thing, that you clear the dues of MB construction. At no length of time, Lordship, the petitioners had taken any loan from MB construction or stood as guarantor, Lordship. How that amount can be recovered, and the bank will is not ready to return my documents on receiving the payment. So my humble prayer is this, Lordship, that after I may be allowed to file a representation before the bank, Lordship, for exclusion of the certain amounts which I am not liable to pay, and whatever amount will come, I will pay, Lordship. And I undertake that I will pay 10 lakhs within 10 days. The statement of account, Lordship, annexed by the bank, Lordship, does not show what rates of interest were charged. There is judgment of the Apex Court, Lordship, 2001, where the Apex Court held that if the statement of account submitted by the bank, Lordship, does not show the rate of interest at different intervals, such a statement of account will not be admissible, and suit is to be dismissed. That is the judgment of the Apex Court, Lordship. Para 47.
Page 107, interest is shown.
Yes, your lordship.
I am ready to pay, Lordship.
And your lordship, the MB constructions amount is not shown in the statement of account, and the balance which we are demanding in the original application as well as in the possessor notice is not inclusive of MB constructions amount.
That is correct. Like the bank has given the letter that until and unless I liquidate the loan of MP construction, the title deeds will not be returned.
Your lordship,
That is the main obstacle, Lordship.
in that scenario, your lordship,
If submission of my learned friend is correct, that has not been shown in the statement of account. How they can give letter, Lordship, to liquidate the loan amount of MB construction?
lien, your lordship, because there are certain liens.
There is no lien. I have specifically stated in my petition. There is no lien, Lordship, or linked accounts. I have clearly stated, Lordship. Lordship, may we please to come to page 14, para 21. Page 14, para, that it will mention in that the TOD, that is the temporary overdraft. Account of MB construction has no connection with the petitioner, and the petitioner has not availed any temporary overdraft loan, and the petitioner are not guarantors in the said temporary draft loan, and the bank has not initiated any recovery process for the said temporary overdraft against the petitioner in the notice issued under section 13(2) of the TOD. Amount is not mentioned, but the bank is illegally demanding the said TOD loan amount from the petitioner. The petitioners are not connected in any manner of TOD amount, and they never took any temporary overdraft from the bank. Then, Lordship, regarding submission of my learned friend that there is a lien, is absolutely incorrect, because if it not shown in the statement of account, if it is not claimed in the while issuing the two numbers of notices under section 13(2), then how that can be realized from me, Lordship? Lordship, may we please to come to page 26, para 42. Page 26, para 42. That the petitioner begs to state that there is no link, lien, SIM in this overdraft account with any other loan or any bank account, guarantee. But after realizing the statement of account, OD account is attached in the original application of the bank, it is found that the bank has debited transfer a huge amount of rupees, heads of loan recovery, an amount of rupees so and so, and the bank guarantee charges, total rupees so and so, without taking consent of the borrower petitioner. The fact is that the reference loan account number 138 does not belong to the petitioner, and no bank guarantee was given link with the OD account. Further, without taking consent of the authorization of the petitioner, the bank has debited his amount in the heads of the insurance so and so, so and so. So, Lordship, when I am not responsible, I did not create any mortgage in favor of MB construction. How that amount can be? My learned friend has correctly submitted that MB account, that amount has not been specified in the section 13(2) notice. That amount has not been shown in the statement of account furnished by the bank. How the bank will say in their two letters that petitioner have to liquidate the loan of MB construction, then only the title deed will be returned. Lordship, here in the second case, when the last notice was issued under section 13, subsection 2 is dated 9/8/23, Lordship. And before that, the OA was filed on 31st of July 22. There is a Supreme, our own division bench judgment, Lordship, which passed by the then Honorable Chief Justice Mr. Chaya. The Lordship, if a notice is served and the opportunity was not given to file reply, Lordship, then in that event, the borrower will be given opportunity to file the representation, Lordship. That is a recent judgment, Lordship. No, एक तो हमारा कुछ नहीं। हाँ? अरे वो हम इसमें लिख दिया। तुम दोनों Lordship, I am pleased to peruse the judgment of our division bench of our this honorable court dated 17/8/22. Lordship,
Just a minute. Please take your seat. Or my model has to be technical. Section 13 to subject 13 subject. Okay. That would be ten. Roy, you are placing which judgment?
Pardon.
You are placing Muslim Ali?
Yes, he is one
Yes,
of
yes,
the-
Muslim Ali Lordship.
Your Lordship, he is also one of the petitioner in this instant case. And he is also a guarantor to the
He
facility.
was wrongly notice was given to Muslim Ali because he is not a borrower, not a guarantor.
I think so.
Guarantors are the petitioner number.
It is in my hand that the guarantee has been signed by Mr. Muslim.
Even if signed by his
It is the original application that has been filed before the DRT level. That is why I am submitting. This is a disputed question of fact.
In case of
Even-
Muslim Ali, your Lordship, I may be pleased to come to page 3 of the judgment, Lordship. At the bottom, Lordship, accordingly, let the matter be listed again with Nana till the next date fixed, no courtship action shall be taken against the petitioner by the respondent bank. So the Honorable Court Division Bench entertained the application, Lordship, petition, Lordship. And ultimately, Lordship,
That order was passed.
no,
That later on, the final judgment was passed on 17/8/2020.
and Lordship, the surprising thing is this, Lordship, Lordship, may please to peruse the section 13(2), which provide that the borrower and the guarantor will be informed to file their objection or representation against the notice issued under section 13 subsection 2. That notice issued by the bank, there is no such provision asking the borrower or the grantor to file the representation, Lordship. And in this case, Lordship, in the Muslim Ali case, this Honorable Court Division Bench held that again the notice will be issued and the borrower and the grantor will be given opportunity to file their representation or objection. Before that,
And is
Lordship,
in section 17.
17 is regarding a filing application before the DRT.
Now, whether in notice under section 13(4) after issuing, taking possession, whether the appeal is not appealable.
Appeal is also.
Appeal is appealable, Lordship, but your Lordship may please to consider if I,
Why should you interfere in writ petition?
Lordship,
Tell us, that is the reason we are asking you. And the act itself is very clear and having an appellate provision. Why should you interfere in a writ?
Lordship may be pleased to consider if I contest before the DRT, Lordship, it will take 4 or 5 years, Lordship.
You will have to
And,
stay
and
order.
the interest rate will, now Lordship, when Lordship may be pleased to consider that I am ready to liquidate the loan.
That you have to play it before the tribunal. Why here? We are not interested in entertaining it. See, these are public money involved. We have seen how much you have paid. Just see. Please come to page number. Had it been regular affair, we would have considered in another way. Please come to page number 90. That's the statement given to you.
Nineteen is regarding the loan recovery of
Yes, that's
other
right.
account.
See, you see the withdrawal part on the left.
90.
All these are withdrawals.
Nine.
Then come first, repeat, page 92. 28th of August, 28th of September 2018. Come to page number 93.
93.
You see your withdrawals on the left and amount that you have deposited.
Deposit.
29th of October 2018, 1.5 lakhs. 29th of November 2018, 1 lakh. 13/12/2018, 70,000. 21st of December 2018, 20 lakhs. But see a total amount that you have withdrawn on the other side.
Lordship, when the account become NPA, I deposited 28 lakhs rupees, Lordship. That is reflected in the,
That's true, that we have seen here, it is
Uh,
there. But thing is this,
no, Lordship, main,
it is, this particular act is only to recover the amount which are a public money.
Lordship,
Not result in a writ petition here.
my humble prayer, Lordship, may please to peruse the section 13, Lordship, of the SARFAESI Act. There is no total violation of the statutory provisions,
You can
Lord.
always prefer before the appeal, you can say. Before the appeal.
None,
forum, you can
Lordship,
just-
against the, if the notice is issued under section 13(2), Lordship, the borrower cannot approach the DRT. There is a prohibition under section 13 of the
Yes, Mr.
Security
Yes,
Act.
your lordship, they have.
Only
challenged
after issuing the possession notice, lordship,
May I please,
the
your
appeal can be filed before the DRT.
May I please, your lordship? In this case, 13.4 has already been issued.
That's why section 17 will come.
And the right of the petitioner has accrued and 17 has come into play, your lordship.
That is the reason we are asking. That
Yes,
is the
No,
reason we have
that
asked
is
Mr.
correct,
Roy to
lordship.
raise
Matter,
section
I'm not denying. My humble submission is that when the, after adjustment, if the bank gives proof that I stood,
And that can
I
be
took the
agitated before
BG,
the DRT.
lordship, I stood the guarantor of MB construction. If they gives documents to me, lordship, then I'll pay the entire amount. Because your lordship, I have sent 3 numbers of letters to the bank that kindly, we are ready to pay the amount and kindly return my document. But the bank is saying that you pay the amount of MB construction. No amount has been specified, lordship. And I am ready to pay 10 lakhs, lordship. The bank will get 10 lakhs immediately.
No problem. Mr. SP Royal and counsel appearing for the petitioner. And Mr. M. Sharma, standing counsel, Bank of Baroda for the resting numbers 1 and 2. Detail order will follow, huh? Reticular. The petition number 1. On his approach. Obtained. Overdraft facility of rupees 70 lakhs. From the respondent Bank of Baroda, Guwahati branch, main branch Guwahati, Guwahati main branch. And in that regard, respondent bank on 25/05/2018 issued the necessary sanction letter for such overdraft facility made available to the petition number 1 by the respondent bank. The respondent numbers 2 and 3 stood as guarantor. As the account of the petition number 1 became an NPA, this full form of the right in detail order. Due to non-depositing of the amounts in time, the respondent bank on 31/07/2023 filed an application being OA number 275/2023 before the Debts Recovery Tribunal, Guwahati, against the present petitioners. For realization of an amount of rupees 58,04,467.59 as total claimed amount as on 0707 2023 for the period from 01/01/23 to 07/07/23. It is claimed by the petitioners that without serving them notice under section 13 within bracket 2 of the Securities and within bracket 2002, the respondent bank, in violation of the Act 2002 Act, preferred the said application before the DRT at Guwahati. And on 08/11/2023, the respondent bank, in exercise of the power under section 13 within bracket 4, as well as Rule 8 of the Security Interest within bracket Enforcement bracket close rules 2002, took the symbolic possession of the land mortgage on behalf of the petition number 1 by the petitioner numbers 2 and 3. Being agree with the actions of the petitioners, the respondent bank, the petitioner has filed this writ petition on 22/11/2023. Praying one, Roman 1. To set aside and quash the said position notice dated 08/11/2023. Only to just quashed. Issued by the respondent bank. Annex 12. This rate petition. Section 17 of the Securitization and Reconstruction of Financial Assets and Enforcement of Security Interest Act provides for a right to appeal, including the action taken under section 13 within bracket of said Surface Act 2002. Matter relates to recovery of public money by the respondent bank from the petitioners. Since there is an appeal provision against such actions taken by bank under section 13 in bracket 4, provisions of appeal is available by the state 2000 Act against the action taken by bank under section 13 bracket 4. where there are proper alternative remedy available to the petitioners. We do not want to interfere with the prayer made by the petitioners for setting aside a safe notice that section notice 8/11/2023 by the respondent bank pursuant to section 13 wicket 2 13 of the code not code the said and 2002 rules noted as the petitioner has been proper remediated leads to them by filing appropriate application for the concern according to its and this
My submissions have not been recorded, my lord.
will do that. That's what the point submitted that the proper account with interest was not provided to the petitioner. The statement of account furnished to the petitioner includes an amount given to some other borrowers. JB, what was the name?
MB
MB Construction.
And I had not taken any BG from the bank.
And the petitioners did not avail any other financial benefit from the bank to incorporate in the statement of account. Furnished by the bank.
One line may be added, lord. 13-2 notice was not served. First,
It is also, no, that was, we have already added.
It has been-
Okay, listen, listen. It is also submitted on behalf of the petitioner that the respondent bank did not issue any notice under section 13 written bracket 2 of the say 2002 Act before initiating the process under section 13(4).
Thank you.
No, एकदम बहुत बड़ा है पकड़ी पकड़ी नहीं
Correct, it's on item number 2.
Oh, itu mah ya. Ya, bukan ada. Ini nggak nih,
Yes, so the please submit.
Lordship, I'm sorry. May I please your lordship?
Please.
Lordship. This, I actually being aggrieved with the order passed by Morigaon Tribunal, bench tribunal on certain matters, in the matter of actually making me foreigner. Although I have all necessary documents and submitted before the tribunal, and tribunal one or other fault, actually opine that actually my entire family members are foreigners. So on being aggrieved, I have actually invoked the jurisdiction of this Honorable High Court, and court was pleased to just entertain me, and I am on bail. Lordship will find that this very under very synopsis, where I have actually found some lacuna, so as to the documents like that of PWD, evidence that like of PWD
DW3 and DW4. These have no mention about in the findings of the learned tribunal. And also, as regards this, this my, actually, as regards Gambura, actually, this Gambura, he has actually given me, given
In this particular order,
Lordship. Tribunal's order.
that's-
Tribunal's order, actually, Lord, sorry, so Lordship, I may actually draw, but your
in
Lordship,
tribunal, the member did not mention what.
Lord, learned members, he first actually, how he actually examined these things, Lordship will find in page 46. 46, DW1 is the opposite party, where they are below line. DW is the opposite party. Short, Sukarjan so-and-so has produced and exhibited some documents in support of her Indian citizenship as follows. Your document exhibit co is a certified voter list of 1965 containing the name of Kitab Ali, son of Abed Ali, a voter of the village Datialburi, whom OP1 has named as her father. So my father's name as father, if not father, he is my father, and he is the father of Abed Ali. However, the exhibit Ho is a certified voter list of 1970, containing the name of Kitab Ali as voter of the Tialburi, village home also and so name as father. Exhibit Go is Kesapata Patta in the name of Kitab Ali. Exhibit Gho is a certificate issued by Gambura of village Datialburi in the year 1915, certifying OP as the resident of his area. Exhibit the Dontia To is a periodic Kriyas Patta having name of Kitab Ali, whom OP has named as her father. I have gone through the entire case record and verified all the exhibits submitted by OP Muhammad Shukurjan Nessa very carefully. Opposite the one, Shukurjan Nessa has stated in her deposition that the name of her father is Kitab Ali. Shukurjan has said that she was born at village Datialburi. She further has said that her father had landed property at village Datialburi. OP Shukurjan has stated on the day of deposition on 1929-16 that her age is 56 years. If that be so, her year of birth is 1960, and accordingly, after 21 years of her age, her name should have been enlisted in the voter list of the year of 1981 and or 1983 for the first time. But opposite party Shukurjan fails to produce voter list of the year 1981 or 1983, having her name been enlisted. OP1 Shukurjan Nessa has named Kitab Ali as her father, yet she fails to establish link with Kitab Ali by any believable linkage document. Shukurjan said her father had land property, and as such, she should have obtained the land from her father inheritedly, through which I could have confirmed in the linkage between Shukurjan and her father, Kitab Ali. But Shukurjan has not been able to produce any such document, so I do not find any believable link between Shukurjan and her father, Kitab Ali, by any document submitted by her in support of her Indian nationality. While OP1 Shukurjan herself has failed to establish her link with her purported father, Kitab Ali, as such, the statement of other witnesses such as DW3 and DW4 are not taken for granted. And therefore, I opine that OP1 Shukurjan Nessa, wife of Akas Ali, resident of village Nitmari, Lahori Ghat present district also and so is a foreigner. DW2 is the opposite party so Akkas Ali, husband of opposite party, who has produced and exhibited her documents in support of his Indian nationality as follows. Exhibit 1, Ungo, is a voter list of the year 1966, containing the name of one Jaimun Nessa, but on the name of husband Jaimun Nessa, clear of her writing is seen, for which this voter list is not accepted. Exhibit Ghoso is a voter list of the year 1971, containing names of one Anjan Andajar Ali and one Akkas Ali, the opposite party number 2. Exhibit Chaw is a sale deed of buying land by one Azhar Ali, son of late Moni or Koni Vepari. But the seal and signature of the office and officer concerned are not legible, so it is not accepted. His another exhibit saw Jaw is a certified voter list of the year 1989, containing the name of Akkas Ali, son of Azhar Ali, and Muhammad Sukurjan, the opposite number 2 and opposite number 1 respectively. Exhibit Jaw is a certified voter list of the year 2010, containing names of opposite party 2 and opposite party 1, along with Mohibur Rahman, son of opposite party Farida Khatun, daughter-in-law of Mohibur and Habibur and Jawur, sons of opposite party. Exhibit Nia is a certificate said to be taken from the office of the Revenue Circle, Guragaon, but the seal and signature used on the certificate are not legible, so it cannot be accepted. Exhibit Madhyanyato is a certificate issued by Gaubura in village Nitmari in the year 2015, certifying OP2 as the resident of this area. Exhibit Madhyanyato is a revenue paying receipt of Azhar Ali, but the seal and signature of the Mojadar and his office are not legible, so it is not accepted. Exhibit Madhyanyato is a revenue paying receipt of Azhar Ali, but seal and signature of D. Mojumdar and his office are not legible, so it is not accepted. Exhibit Madhyanyato is an affidavit sworn in by opposite party 2 respect of name, discrepancy of the opposite party and his father, etc. But affidavit is not considered as an evidence. Exhibit Madhyanyato is a photocopy of the legacy letter code Azhar Ali, so it is not accepted. Exhibit Dantia Tho is a revenue paying receipt of Azhar Ali. For exhibit Dantia Tho is a revenue paying receipt of OP2 of the year 1977. Exhibit Dantia Tho is a revenue paying receipt of opposite party number 2 of the year 1981. I have gone through the case records and verified all the exhibits produced in favor of the DW2 Akkas Ali very carefully. DW2 has stated in his deposition that the name of his father is Azhar Ali. DW2 said that he was born at village Kishanguri. DW2 has stated in his age as on 21st/9/16, about 60 years. If that be so, he was born in the year 1956. Accordingly, after 21 years of age, his name should have enlisted in the voter list of 1977 for the first time. But instead of it, his name enlisted in the voter list of 1977. That is in 1971 itself, and when his age was shown about 26 years. And if I go by this voter list of 1971, so where OP2's age is shown as 26 years, and then I see that the year of birth of OP2 Akkas Ali, husband of Sukurjan, is 45 years, 1945, and 21 years of his age. His name should have enlisted in the voter list of 1965 1966 along with his father Azhar Ali and mother Jainal in the same voter list, but it is not seen in respect of OP2 Akas Ali. So I see that OP number 2 Akas Ali has miserably failed to establish his link with his father Azhar Ali or mother Joyman Nessa, although DW2 has produced evidence in favor of opposite number 2's Indian citizenship. Yet, while OP number 2 himself has failed to establish link with his father Azhar Ali, the statements of other DWs cannot be taken for granted. Besides, the opposite party too has said that his father had Meadi land at village Kapurpura, but OP2 has failed to produce any land document obtaining land inheritably and his father Azhar Ali. So I see that the opposite party too, Akas, has failed to establish link with his parents named Azhar Ali and mother Jaiman Nessa, but producing any believable documents. Prior to 1971, and accordingly I opine that the opposite party to Akas Ali, son of Azhar Ali, resident of village Nitmari, PS Lahori Ghat district Iman, is a foreigner. And as such, while OP number 1, Kuljan Nasa, wife of Akas Ali, and opposite party 2, Akas Ali, are declared as foreigners who entered into India on or after 25/3/71. Accordingly, their sons named Mohibur Rahman, Hafizur Rahman, Jabul Rahman, and Isabul Rahman are all foreigners. The district authority concerned should take immediate steps to push them back to special territory, specified territory. This reference is answered in affirmative. The reference is post contest in so. This is the tribunal's finding, Lordship, entire the facts and circumstances of this matter. So my humble submission before your Lordship, there are actually such things are exercised and throughout last so many years, and so many actually foreigners matters are before your Lordships. And Lordship, considering these aspects, in some genuine cases, that there has been actually stay or what is ordered or a sort of this bailing authority. Now this in the form of this admission, Lordship, it has come before your Lordship. I humbly submit before your Lordship that here this Sukurjan Nessa, wife of Kitabali, she has submitted her voter list of 1965 of Kitabali, page 18, Lordship, in this modified petition. Voter list 1970 Kitabali, that is also page 19, that has been done. Kesapatta in the name of Kitabali, page 21. Gaon certificate, link document with father Kitabali, that is page 23. Periodic Khiraz Patta in the name of 25, in the name of Kitabali, that is also 25, Lordship. Jamabandi copy, although not produced, the name of Sukurjan Nessa muted along with her other brothers and sisters at serial number 4956. Tribunal's finding at page 47 that now I have actually read out down below about non-furnishing of land inherited by Snasnari. Here inherited by Sukurjan Nessa. In this matter, I humbly actually after that my entire property has been sold by Brahmaputra by erosion. So that circle officer also has given me that the certificate. But under circumstances, whatever, I, with my endeavor, after expressing my all positions to our parent relatives, this document which clarify the position of this honorable, this High Court, our High Court, which is our only hope where I have invoked the jurisdiction, and Lordship will excuse. Excuse me. Lordship, I, sorry. Okay. Okay. I will, this is governmental. My honest endeavor, Lordship, I'm just trying to impress upon your Lordship. This is the certified copy of the land document, which I actually could not produce at that time because of various circumstances prevented me from collecting this from my parents. If tribunal is to be satisfied with such documents that I should inherit some land from my father, parents, in sense actually in a Muslim Islamic way of life, the married daughter, if she is in distress, then she may claim, come back home and get actually this work of properties or parental to and us. This sort of provisions were there in Hadith and Quran and all these things. But there was no such thing that unmarried daughter will be given the property of the parental house actually along with the brothers. It was actually not there, not in a customer way it is happening. In the distress circumstances, always girls are given the proper treatment by the parent in the parental house, by the brothers or having this property, this some share, all their life. And work of board and all these things were there are provisions some other way. However, here is these are the others only will find serial number. Actually, it is really very ineligible, looks like 49 Lordship. Lordship will see that here 49 serial number. The serial number 49. This is the from the family members' name starts Nur Jahan Begum. Up to the bottom of the list, one left, Lordship will find 55. 55, there is a Sukurjan Nasa. Sukurjan Nasa 55. Starting from 49, ending with 56, there is 55 Sukurjan Nasa. She is the daughter of that Kitabari. She is the Sukurjan Nasa, a daughter of Kitabadi. This is the land document that I have actually placed before our Lordship. Kindly this paragraph where it is the governmental record. This article from this certified copy. This query from the side of the tribunal. If tribunal at the lowest actually inquiring court, if this copy requiring to produce before them, actually that was not done, and he is actually passing my record of the entire assessment. He has actually negativated. Voter list, he says that this is not reliable. My father's relation not sure because the linkage I have not been able to linkage. I have lost it. So here is the linkage with father and daughter. This linkage is sufficiently shown here. So this document, when it has come to me under various circumstances, because during those periods, heavy flood, so many things, Brahmaputra, we are nearby Brahmaputra, resident of Brahmaputra. This Brahmaputra that I am nearby the resident, that certificate has been issued by the circle officer also, that my property has been sold by Brahmaputra River. So under these circumstances, like nomadic tribes, I move one place from another to stay with the along with the children and all that. At the time, it's actually happened like this. Under that serious circumstances also, I had to maintain myself with the members of my family. And here, Shukurjan Nesa's father's link with Kitab Ali was not shown at the time of evidence, all that. That is why he has by PW the evidence, DW 3 and 3-4, whose statement was there. They are the local person whose evidence was necessary. He has said that I am not accepting all these things. Overwriting, I have never touched any paper. It has come from the office. Voter list, having voter list, all the relationships of my family, members of my family. He one or other reasons he finds fault with me. So I am unsophisticated class of people living in village. And such a one square means actually to get, actually this is my endeavor throughout the day. And voter whose name will be included in the voter list at a proper age. Is it actually in a sophisticated class also? Sometimes people's name are left out. Voter list may not be always criterion to determine a person who is a citizen. It may gradually happen. Voter list enumerator will go house to house. They will collect names, others, and all that. So collection of names sometimes lacking, and somebody's name left out. Nowadays, the seriousness has come because of state or so many political many things happening. That is why seriousness has come during so many years. But earlier it was not there. I am a man of lordship. I am a man of 88 now. I was born in 1936, 27th of January. I am still alive. All the members of my family have actually expired throughout, in my family also. But my name has been in a voter list. It is in some, my name is Huda. One in the voter identification card, there has been written Hawk. In the voter list, I was respectfully submit, also. I was in the various political life also. I was here and there also. I am known persons also. Even then, my name is shown incorrect. So this happens. So under the circumstances, entire family, such a big family with the children and all this, should not be negativated in this manner, putting them from distress to distress. They are suffering terribly. This is actually against the canon of justice and fair play. So I have come. Highest court is highest court. Highest sobriety, and all these things demands that some sort of human behavior to be meted to such this poor class of people. I always say so. In earlier also, in this high court, there were so many in the tribunal. Most of the tribunal foreigners' cases actually came to me, knowing that I am socially or politically, I was actually known to each other. That is why they rushed to me, and accordingly, I tried to discharge my duty that way also. In the whole court, in the court premises also, so many queries and things actually I had to face. Now I humbly submit before your lordship. Here, a few days before, Doctor. Here also, a few days, the last month or earlier, in another case, lordships actually produced your lordships, our Bujol Borua and the bench. They actually referred this matter back to the tribunal to justify, to produce this evidence. Here I humbly submit that Tambura's evidence not testified. Opposite this government, this other side to actually cross-examine him as to the veracity that whether this lady belongs to his village
this guard was given marriage to some other, he knows, as he has actually given a certificate. So that part, at least from the opposite sides also, that query should have been there before the court in the tribunal premises, but it has not been done. It seems that on record it is not there. DW3 and DW4, their testimony so important. There is a village person, responsible person. Why tribunal could not actually keep those things in confidence that this is a legitimate evidence actually used before? So only to make negative, only to create trouble to this citizen of India by birth. Actually, this order has been so passed and warranting me to just come before your lordship invoking this jurisdiction for my rescue, also, for the rescue of the entire property, entire family. So here, this copy I have just given. So these are all things are there, lordship. I can actually, how can I? Lordship knows many things are here. Number one, Sukurjan is the daughter of Kitabali. I have established this thing.
Sharma.
ठीक है, अगर पूछा गया तो देखो अगर
Lordship. Yes, Lordship.
We have marked the note. There are 3 flag marks where we great pencil each and every. Which is notice was issued by the reference.
Yes.
I don't know why. But from the record reveals, it is only with
Sukurjan. So Lordship.
the other goes.
Yes.
Right?
Yes.
All the other procedure, whatever direction given. it is
Yes.
right. Because the investigation was only with
Sukurjan.
It is one. Secondly, from the record since it is in your hand, tell us whether the evidence adduced by Sukunasa is sufficient to prove her link from Kavali, our protected father. Tell us why it is to be accepted or not to be accepted.
Yes.
They are produced two Kutali, 1966 and 1970.
Yes, sir.
In one voter list, there is the name of Kitawali alone.
Yes, sir.
In the other voter list, there is another person along with Kitawali.
Lord, sir.
One of Abed Ali or something.
Yes, sir.
Now, the link document.
Only Gavra certificate. Sir.
Now, a certificate. Now, two things are there. Gangura did not introduce any evidence.
Yes, sir.
Secondly, Naupura issued the certificate.
Yes, Lord.
There is no mention that it has been issued from the
Lord.
Naupura did not deduce any evidence.
Yes, Lord.
So that part not proved.
Lord.
So tell us the law.
Yes, Lordship. Lordship, from the repetition I have changed, Lordship. In page 24, Lordship.
Yes.
ইয়াৰ দ্বাৰা পৰিচয়পত্ৰ দিয়া হয় যে চুকুৰজান স্বামী কিতাপ আলী
Not.
yes, not
It is
Sami.
there, it is there, the
Yes,
evidence
Lordship.
is there. Just
Yes,
the
Lordship.
record it is there.
And yes, Lordship. He is the village headman of village Borbari, Lordship. This is
Borbari, Datialbari appears from the down stamp. You do not know.
yes, Lordship. In everywhere, Lordship, it was overlapped. Firstly, I am telling Lordship. Secondly, Lordship, it contains the state emblem at the top of the certificate, Lordship. First, it is not a admissible evidence, Lordship.
Okay.
Lordship, regarding that, Lordship, I want to rely on a judgment of this honorable court, Lordship. So many judgments are there, Lordship, regarding state emblem, Lordship. One is WBC 3728/2016, Nasiruddin versus Union of India.
WBC
3728/2016.
2718.
3728/2016. Nasiruddin versus Union of India.
Then
where it has stated that unauthorized use of state emblem would render such certificate inadmissible in evidence, Lordship. Again, Lordship. Then, Lordship, Lordship, under case, Lordship, I am going to rely, Lordship, WPC 4512/2016.
4512/2016.
4512. 4512, Lordship.
2016.
Yes, Lordship. Muhammad Fakhruddin versus Union of India, Lordship.
Yes, then
Lord. Lordship, in page, Lordship. After discussing the tribunal's order, Lordship, High Court quoted this. I am quoting this line, Lordship. A perusal of the aforesaid order passed by the tribunal would go to show that tribunal had appreciated whatever evidence were tendered by the petitioner and thereafter had returned the finding that petitioner was a foreigner who had illegally entered into India from Bangladesh after 25/3/1971. Thus, a finding of fact is ordinarily not interfered with by the writ court, unless it is a case of violation of principle of natural justice, procedural impropriety, or if the impugned finding is not based on any evidence on record, in which event it would be a case of perversity. This is because the jurisdiction exercised by the writ court under Article 226 of the Constitution of India is supervisory and not appellate, Lordship. Lordship. So Lordship, oh, tribunal has discussed all the things, Lordship, what was before the tribunal, Lordship. And Lordship, regarding Gaubra certificate, Lordship, which is only linked document here, Lordship. And Gaubra death certificate is not admissible in evidence, Lordship, due to using of state emblem at the top of the certificate. Apart from that, Gaubra is not authorized to issue such certificate, Lordship. And this issue has been settled in so many cases of our High Court, Lordship, settled by this Honorable Court, Lordship. In WBC 7451 of 2019, Lordship.
7451
of 2019, Lordship, where it has stated that tribunal rejected the exhibits 9 and 10 on the basis of the fact that Gaubra are not entitled to issue certificates supporting the citizenship of a person. The tribunal also rejected exhibit 13 on the ground that it has not been proved. Finally, the tribunal held that the petitioner failed to file documents linking herself with her projected parents. Apart from that, Lordship, WPC 4271 of 2019, Kobir Khan's case, Lordship. In earlier occasion, also I have submitted this case, Lordship, where it has stated that accordingly, except for a Gaubra certificate issued by DW3, there is no exhibited document to prove that the petitioner is the son of his projected parents. The opinion of this court, the said exhibit D cannot be accepted as a proof that the petitioner is the son of Shakur Khan because the DW3 in his cross-examination had stated that he had issued the certificate as per his personal knowledge. Thus, his certificate is not based on any public record maintained by the said Gaubra. The said DW3 had clearly admitted in his cross-examination that as per the executive instruction part 4 chapter 8 of Assam Land and Revenue Regulation 1886, he was not authorized to issue such certificate and that he had issued that certificate without being aware of the said executive instruction of Gaubra.
anything else?
Yes, sir.
Whether Gaubra adduced evidence?
No, no, Lordship. No, Lordship. And in this case, Lordship, petitioner produced one Jamabandi copy, Lordship. Certified copy of Jamabandi copy, Lordship. Then, yes, Lordship. That cannot be accepted at this stage.
No, let us assume it is there before the tribunal. Let us assume it is before the tribunal.
Yes, Lordship.
At a time of consideration. Whether it can be accepted as evidence to link, to prove the link between the prosody and her protected person. Let us assume it was there before.
Yes, Lord.
In that case,
because in this zone, that cannot be accepted because Lordship, in this case, Lordship, here, earlier order of the circle officer, Lordship, first order, Lordship, in that land was by way of purchase, that land was mutated, Lordship, in the year of 1985, Lordship. So this is a post 71 document, Lordship.
so the name of Itabali
Yes, Lord.
was incorporated only in the year 1985.
Not Kitab Ali Lordship, grandfather of the petitioner, father of Kitab Ali Lordship, Abed Ali Lordship, Sorjomin Chitar, Putoro dos, Posasi Tang, Hukumote, Corina do Holutres, Sarinong, Egg Biha, Kota Mati, Mendu Akon Pita Abed Ali Namot, Namjari Hoy. So here also by this document,
Purchase was in 1985
yes, Lordship,
by the grandfather of the protected grandfather of the property.
yes, Lordship,
So it is a post 1971 document.
yes, Lordship. And that certified copy is also obtained after delivery of the.
Doesn't matter, that order is very clear.
Yes, Lordship. And Lordship, if we ignore the Gawra certificate, then there is nothing
Which
to.
serial number it is there in the reports of the circle office?
Lordship. To Kurjan's name,
No. The name of grandfather of
no,
Kitab Ali.
Lordship. Actually, by this document, Lordship, they cannot prove the existence of her grandfather, Lordship, because here it was written that for Lordship, first right hand column, Lordship. Sorjomin Chitar, Putoro dos, Posasi Tang Hukum Mote Corida do Putre Sarinong Logot Egg Biha, Kota Mati, Mendu Akon Pita Abed Ali Namot, Namjari Hoy. So, Kitab Ali to ketia hile. Lordship, I could not find Lordship when Kitab Ali's name has been mutated, Lordship, in this Jamabandi, Lordship. Order to order. Itu naam to aste to order to. Kitab Ali against order.
Mr. Huda, the document that you have placed before the court should have the name of Kitab Ali. Do you think that please? Do you have stated the family members of Kitab Ali figured from 49 and the name of the procedure serial number 57?
Yeah.
But where is the name of Kitab Ali first?
Only This document has come to my hand, Lordship. Here,
Difficulty, see,
this is
that's
the,
the reason we're asking you, even if we're assuming. First of all, the name of Kitabali have to come. Where is that Kitabali?
Kitab Ali has been shown as father.
Where?
This is page, Lordship will find it starts from
Hmm.
serial number,
No, on the right hand side in the second page.
yes. The second page. Kitab Ali, yes, Kitab Ali. It is written there, the last. The
right-hand
second page. ভৱিষ্যত তাৰিখৰ নামজাৰি so and so ডাগৰ ইমান নাম্বাৰ কিতাপ আলি স্থানত নুৰজাহান
Right, we understood. Now, where is the Kitabali? In that particular list.
in the particular
List on the left. Where is Kitabali?
Kitab Ali has been shown as the actually father,
First of
meet
all,
of
name
father.
Kitabali have to be there, no?
Yes, Lord.
It should be Patadar. Where is the name of Kitabali?
Kitab Ali here, Kitab Ali has been shown as dead person, expired, Mito.
But his name definitely would be there.
Yes, Lord.
Their property, their relations patta, that starts from 49 to up to
Fine, but
56.
where is the name of Kitabali in the land document? In the left hand column, Pattadar or Nam, Pitar Nam, that's the column number 3. Where is the name of Kitabali?
This has come in the certified form before us, which I have actually given.
See, first of all, Mr. Huda, that yes, one Kitabali existed. He had a land, he had land, he had purchased land. His name was mutated.
That is where there are.
But in the list of landholders of this particular patta, number 278, right?
Yes.
Where is his name? This particular patta, tag number 158, patta number 278. Where is the name of Kitabali?
Kitabali is shown as dead person, father of so and so, dead Mito.
Prior to that.
That has been shown.
Normally what
this year.
happens?
So land has
Land
been.
may be name of Mr. ABCD. Now, his son, XYZ, during his lifetime, did not mutate his name. He has also expired. Now, the legal heirs of XYZ may apply for mutation of their names in place of XYZ, who happens to be son of ABCD.
Yes.
So there has to be first an ABCD. The ABCD name will be deleted, right? As the
Yes.
system we have seen.
That too.
First off, there will be land, is the patadar of land, particular dog. ABCD will be there. Then ABCD's name will be struck off
Yes.
by dotted line.
Yes.
Then the name of XYZ will be there. Because his name have to be mutated. Then XYZ also name will be deleted by the striking of the line. Then there will be an order of the circle officer that such and such and such and such.
But this is
such and
still,
such,
still
the
with
name of
the,
such and such will be there.
still different,
But
yes.
where is the name of Kitabali?
Yes. Kitabali's name possibly is there on the record, but they could not actually get this or did not put their mind in that regard. Only they are interested to certify, get this copy and got it. And these people.
Link of father and grandfather also not established by this document.
Not indeed. Here, this is actually ইমান তাৰিখৰ ইমান ডাগৰ ইমান মাটিক মোহাম্মদ কিতাব আলীৰ স্থলত নুৰজাহান বেগম মৃত কিতাব আলীৰ আবু অমুকৰ নামত নামজাৰি কৰা হ'ল আলীৰ নামত নামজাৰি কৰা হ'ল This is actually second page the document it is there the last text. The name of Kitab Ali is there very much. Not that Kitab Ali is an unknown person. Kitab Ali altogether, their grandfather, father,
In that case, there will be an order of the circle officer. How the name of Kitab Ali has been
Yes,
incorporated in the Jamabandi. It has to be on the right hand column under the remarks column.
Yes.
Where is it? We are trying to find out. This Jamabandi is not helping you.
Yes.
So Mr. Huda, tell us what to do.
Okay.
Now let us see your written statement.
Yes.
That will cleanse all the issues.
Yes.
Where is your written statement?
I will here.
Have you annexed?
I mean, yes, yes.
13 to 16.
Huh?
13 to 16 page.
Okay, just a second.
It starts from para 8 with regard to the proceeding, then petitioner number 1.
Yes. That's a platinum statement 5 signs opposite party. Page 13.
Page
Here
14.
actually 1, 2, 3, 4.
In page 14,
Page 14.
paragraph 8.
Paragraph 8. That
That
from the
starts with
certified copy of 1965, the name of the father of the opposite party number 1, namely Kitab Ali, son of Abed Ali, was appeared in the voter list of Assam Legislative Assembly, number 84, Lahori Ghat constituency. By that time, district was Nagaon. The bifurcated, not the bifurcated. Here was Lahori Ghat and village was Datialbari under Moirabari Mouja at part number 68, house number so and so, so and so. That from the certified copy of 1973 state constituency, the father of the opposite party number 1 was enlisted as Kitab Ali, son of Ared Ali. Kitab Ali and Kitab Ali was same and one person. So spelling the some proper name somewhere it has been mistake. To a mistake of election department of the name Kitab Ali was written instead of Kitab Ali. Kitab Ali was the son of Abed Ali, Arad Ali. This way. The opposite party number 1 is legally married to the opposite party number 2, and in this regards, that the concerning Datialbari Gaobura given a certificate of identity for marriage of the parties. That the certified copy of the year 1989, the Assam Legislative Assembly 81
That
number.
relates to OP number 2. That's why we have not related.
Yes.
Only with regard to the petition number 1, paragraph number 8, 9, and 10.
8, 9, and 10.
There is no more, right?
Yes.
What we have seen from this written statement.
Yes.
Here, she projected her father as Kitab Ali and his grandfather as Abed Ali or Ared Ali.
Arad Ali, yeah.
Good. let us assume paragraph 14 also is in your favor.
Yes, 14,
So
14, 14. The total,
9,
total Gambura of the opposite party. Village friends so willfully knows their predecessor of the opposite parties and knows very well of the opposite party of the instant case.
Mr. Huda, in this written statement, if petitioner number 1 did not state that her father or her grandfather had land or purchased land or had regulatory rights over some land, there is no mention in that regard.
That written is just actually written by this or helped by the advocate from the respective petitioners. And this is checking that could have been written there, but instead of that, but declaration is such in the written statement that he is the Kitabali and the same person having all this. And the erosion certificate and all that given by this government responsible officers, knowing them fully that they are the persons of that locality and deciding their kind memorial. These things actually cannot be denied, or nobody will say that they are not still a bona fide president of the place.
Where is the link document? That's the reason.
That has become a matter for me sometime.
You got
Also
the
like,
daughter of Kitabali. Where is it?
so
Which
land
document?
Land document that has been shown that Kitabali's name is there and his children and offspring.
Now you have not mentioned when did he died. What is the name of your mother? There is nothing.
That was not actually at that time required or somewhere. I thought that
How can you be in art without your mother?
Definitely
The
without.
judgment of the apex court in the Sarvananda Sunwali's few facts made it very clear by the Honorable Apex. The name of the parents, not only father or mother, both place of birth. These are very important issues when we get specified in that particular para 26 or 27, 26, I think. Everybody is avoiding to show their name of their mother. What is this? नहीं तो है वाली ना बोले ना Mr. Huda,
Lordship.
with regard to the petitioner numbers 2, 3, 4, 5, 6. This order of the tribunal will be set aside. 2, 3, 4, 5, 6, because what I have sent it to Mr. Verma is that proceeding was initiated only with the petitioner number 1. So it will proceed only with regard to the petitioner number 1.
Lord.
So that part goes.
No,
Now, with regard to the petitioner number 1, what we have found that the petitioner, said petitioner, except placing those documents, fail to prove anything. Mere placing the documents will not do. There has to be an evidence, neither the Gambura or any other. Difficulty is, you see, when you want to case this, and not a foreigner, you have to keep a detailed list. Now, in the written statement, there is no mention of that accepting saying that Kitapali is your father. There is no mention about the mother of the proceeding. There is also no mention about the wife of Kitapali. In the written statement, there is no mention that these are my brothers and sisters. These are my brothers and brothers definitely may be resident of the Tialbari only. We do not know. There is no mention. Suddenly, placing a document maybe before the tribunal, having so many brothers and sisters, son of Kitapali. Not there. So, in fact, the best part to having such evidence been placed before the tribunal,
Yes.
not been placed by the prophet. You cannot say that now you cannot interfere with the finding of the tribunal that if petitioner number 1 fail to produce sufficient evidence as required under section 9 of the corridor to prove her. So this is the bounded duty of the proceeding. Who is only aware about her real fact? Who is your father? Who is her mother? Who is her brother? Nobody else will know. To prove her link along with Kitapali, son of Vedar, something strong.
If
Why
that
you
is,
have produced the hotel list, but where is the
and at this stage, as Lordship is from your Lordship's mouth, if this is so important at the present case, actually, should we take that course now by actually filing an additional affidavit?
question is whether our power sitting here the 226 exercise the power on the 226 only to verify whether the order of the tribunal is good in law or bad in law.
That's all.
We have from the records we found that the proceeding against the petitioner numbers 2, 3, 4, 5, 6 is bad in law. To that extent, we will set aside the order. But what about the petitioner number 1? It is the duty of the petitioner number 1 to establish her case that she is not a foreigner. And Kitapali was her father. That has to have been established, as you have said, paragraph 8, 9, 10, and last 14. Neither the village headman have proved the document. Above that, the certificate with the national emblem, which any such certificate with the national emblem used by unauthorized authority becomes a.
I don't take your Lordship in judgment. This matter, Lordship, I actually just a question in my mind. What was the position of this petitioner, Sukurjan, after having this present the order as Lordship will pass, by passing on?
With regard to Sukurjan, will be finding of the tribunal will remain. With regard to, because with the other cases, her husband, their children, that will be set aside.
He has become aged now, 63 or something like that, 57
What to
at
do?
16 years.
We can understand.
Yeah, yeah.
This is a case of 2010.
And,
This initiation was of 2000 or before that. Is there 2004.
yes.
SP border Morigaon.
If Lordship passes,
October 2004.
making a certain stream open to the high, the she may satisfy the court subsequently by way of filing necessary documents. That way Lordship will protect her.
How, there is no such provision. In that case, whoever we find that the order of the tribunal is correct, but to give a chance, we have to require to send it back.
Again, that will take much time and all things. If for the stem that the Lordship is now proposing, that is actually beneficial to my client. At the same time, Surojma, the mother, if she is to be protected somewhere rather,
Where
then
from the protection will come? It will be, that is the thing we are asking you. That is the reason we are asking you, show us any document. to
then he is
register.
ailing
See,
lady also.
basically, first of all, the name of father, name of grandfather, name of mother, name of grandmother, name of her own brothers and sisters, not there. There you can say. Just see
Lordship.
one thing. Before the tribunal, queries were made to her. There, her clause, she stated, school certificate দাখিল করা নাই। LP স্কুলত পঢ়া নাই। জন্মৰ certificate দিয়া নাই। জন্মৰ চন কেতিয়া মনত নাই। দেউতাৰ মাটিৰ পাট্টা নম্বৰ মনত নাই।
হয়।
ঘৰত থকা মাটিৰ পট্টা নম্বৰ নাজানো।
It is necessary. We do not know that.
Necessarily, these things, so that is the reason we are asking you. Even here, she did not disclose who are her brothers and sisters. Right? So you know the fate. That's what Mr. That's Mr. Z Sharma, Semi Council, Department of Transportation. Put it as one of the- with- Mr. P. Sharma, Mr. Hadari. Not for that, let us- Impugn judgment in order dated 30/12/2016. Filed by the Garnet Tribunal, Moregaon. In FP within bracket C. Number. 327/2015. Within bracket. FP within bracket C, bracket close 233/2012, full number. Plus. IMDT case number 10. Bracket 13/4. Bracket close. Dated 30/12/2016 with regard to the petitioner numbers Muhammad Abbas Ali, son of late Azhar. Petition number 3, Muhammad Mahibur Rahman, son of Abbas Ali, in bracket petition number 2. Bracket close. 4, Muhammad Hafizur Rahman, alias Habibur Rahman, son of Abbas Ali, petition number within bracket. 5, Muhammad Diabur Rahman, son of Abbas Ali. 6, Muhammad Isabur Rahman, son of Abbas Ali. Set aside in cost. As from the perusal of the reports, we have seen that the learned Nandun writer, the Superintendent of Police Border Moregaon, initiated the proceeding only with regard to the petition number 1, Muhammad Sukurjan, alias Sukurjan Nessa, wife of Abbas Ali. But the tribunal issued notice to all the family members of the petition number 1, Muhammad Sukurjan Nessa, as well as the petition number 2, Abbas Ali. Petition number 1 and 2, Muhammad Sukurjan. Got it. Side. Or with regard to the petition number 1, I have decided that order of the tribunal, it is such and such. Pertaining to petition number 1 doesn't call for any. But the observing opinion that by tribunal. This vote. Therefore, order.
Lordship, thanks.